Good afternoon, everybody. I'd like to make a start now for the afternoon session of the inquiry on day 11. Apologies for delaying the resumption of the inquiry today. It just took a little longer for us to get back from the site visits than I'd envisaged yesterday afternoon. Yeah, thanks. Just want to make sure that everybody's aware of where we've been on the site visits. We started off at Thatched House Farm, saw the pond that had been referred to and the relationship of the boundary of Thatched House Farm to the appeal sites at Lidger Park. We then walked along Dunsfold Road, heading east, and at the bend where the road becomes Stovolds Hill, we turned left onto the footpath, which is footpath 277, and we made a point of stopping at the viewpoint immediately beyond the first farm buildings, which I think was agreed was Mr. Dudley's viewpoint 8. Walked up the hill and then turned to the west, just below the more densely wooded area at the which goes on to the top of Hascombe Hill. So there we were on footpath 279 and went as far as viewpoint 7. We returned by a different route, which enabled us to go down byway 278, ending up at the same point on the bend where the road changes names. And from there we went into Lidger Park. We saw went on each of the 4 appeal sites. And we also had a walk along Crocus Lane, looking at what we could see of the ditch, which wasn't apparent until we got a little way beyond the access road to sites C and D, and appeared to be roughly coincident with a stronger tree line, and then walked along there to the junction and ended up going up Stovolds Hill till we could see the gates across the road into Dunsfold Aerodrome. So that's the extent of where I've been on the accompanied site visits. A few points I've got to catch up with you on documentation. The first is I asked for an agreed note on flood risk details on factual matters, nothing in terms of commentary. I haven't had a chance to check whether anything's come in by way of emails from my office this morning, but the last time I checked yesterday evening, I just had the draft from the local planning authority. Now, I don't know, Mr. Masters, Mr. Cottle, whether any progress has been made on that.
I'm unable to assist at it.
Mr. Woods, you dealing with it? Sorry?
I wasn't aware I was dealing with it, but I'm not, because I haven't had any instructions about it. So what am I supposed to be doing? I don't know.
Sorry, I'm not sure what the situation is with that. I know that there was Australians yeah. Is your microphone on, Mr. Masters? I'm struggling because of the air conditioning again.
Sorry, it isn't. What I was about to say, so I know that there was some email correspondence between Mr. Quigg and Mr. Smythe. So I thought between them they were going to come up with something, but I haven't heard anything more.
Okay, well, perhaps we'll have at least one break this afternoon. So perhaps I'd be grateful if the appellants could just check. I'm certainly aware that there is documentation from the local planning authority, and I simply wanted a recorded matter of fact on those queries that I raised. Next on my list is the records, Mr. Masters, that you said you'd put in today.
So
I think it's in relation to C and D.
They are just being photocopied.
So it's in hand.
It's in hand.
Okay, that's all I need to know for now.
And so the schedule of occupants,
Yes,
I do have to hand.
Right.
I'm grateful. I had a disaster yesterday, sir, in the sense they got home and the internet was out. Much to the chagrin of my daughter and son. BT promised it would be cured, but it hasn't been so far. So unfortunately, I couldn't download anything to print off because I couldn't get to my emails.
well,
So,
but to cut a long story short, have you got it now?
yes,
Well, let's put it in, and I don't need any more detail. And this is for sites A, C, and D.
this is, yeah, and it's the occupants. It's a change of the occupants. Names. Yeah, and what I was about to say is there's like, thank you, council, because they printed it off to me.
Thank you, Mr. Masters. Mr. Masters, this goes beyond what I'd expected in that it's giving additional information concerning personal circumstances.
Um,
What
so-
I asked for was a schedule of occupants.
So I can, if you're happy, I'll, all I can do is
Well-
I hadn't seen this. It wasn't prepared by me. But I'm happy to amend it, sir, and, get it emailed to you by the end of today.
Well, I'm not, having said that, I mean, I'm only quickly glancing at it now for the first time, but
I don't think,
as far as I can tell, it appears to be consistent with the evidence that was given at the inquiry.
but
I'd
that's,
certainly be concerned if it's introducing new material.
it's
at
not
this stage.
introducing anything new, sir. It's only matters that are already there in the documentation. But I didn't ask for that to be done in that
Well,
way.
there are some new things. For example, what I've just spotted, and I'm sure this wasn't mentioned, is on page, I think it's 2, 4, probably page 7, and it's about Ned Johnny Smith, who's an appeal D. And in the final column, it talks about transition from mainstream education to full-time homeschooling. I don't recall any reference in the evidence that was given to homeschooling.
No, sir.
It's not the,
James has obviously been a little enthusiastic in putting in probably more
Yes.
detail than he needed to. And it's my fault. And the problem is because I couldn't see it last night, I wasn't able to edit it. I would have edited it out.
I mean, that's just one thing I've quickly spotted. There may be other things as well.
Should we take it back?
I think so. I think rely on. Thanks, Mr. Masters. Okay. Yes, it's a schedule of named occupants and names of those 18 plus. Clearly, they're the adults.
That's what you'll get, sir.
Thank you.
Could I ask for that? I wonder if I could ask that I'll amend it overnight.
Yes.
Get Mr. Rowe to send it to.
Yeah, send it to the case officer, Alison Dyson, please.
Thank you. I'm sorry, sir.
It's okay. Mr. Cottle, have you got your schedule?
I thought that was emailed yesterday. You received it.
Well, as I said, I haven't checked since yesterday.
It was
evening.
emailed to the case officer yesterday, as I mentioned in the inquiry.
Yeah, well, it may have been, she may have emailed it on this morning and I simply haven't had a chance
'cause I
this morning.
just marked it up as requested by the inspector.
Yeah.
No.
Right, well, let me check that then.
Okay.
And one thing, Mr. Linton, I just want to check with the local planning authority. There's been reference made to further planning permissions being granted at Lydia Park in recent years. Now, I'm aware I've got a schedule and plan from Mr. Ward. I think it's CW's Appendix CW 16, and I think there are two supplements to that, A and B. And the question simply is this. I think CW 16 starts at 2017. In other words, before the decisions on these appeal sites. If I look at that information, CW 16, is that comprehensive? Does that give me a full record of recent decisions on traveller sites at Lydia Park?
So I think the only addition to that is I'm trying to think what the reference number is. I can't remember offhand, but is the decision at Ranch Park, which increased from 5 pitches to 10, and you have a copy of that.
I asked for details of the total number of sites.
It was attached to the
and
back of that.
I've got an attachment to that. So
Yeah.
If I include that in it, I've got the information.
You've got all of it, I think.
Thank you.
Did that include the one we saw on site today, sir?
I don't recall a further planning permission being pointed
No.
out.
My understanding it's an unauthorised development, but
Yes, I'm talking about planning permissions.
oh,
So
I
if
see.
it's unauthorised, it wouldn't be a planning permission. Okay. So these are the health documents in relation to sites C and D.
They are, sir.
Thank you very much.
The,
You got a copy for the council?
I have. Again, photocopy.
Thank you. And just, I think, two other things to check in terms of documents. The tree preservation order.
Yeah, that's been sent through to your
Thank-
office, Inspector.
thank you.
It will have an ID number as well. Whether it's got one yet, I'm not sure, but it will
Yeah.
have.
Okay, thanks. And then something that cropped up last night when I was checking plans for the site visit, and I raised this at the beginning of the site visit with the parties, but everybody needs to be aware of it. There's an appendix to Mr. Ward's proof, CW 13, which shows the AGLV and national landscape boundaries, and it's not consistent with the plan, which I don't think has an ID number yet, but it's the plan which shows the alterations to the national landscape boundary that Mr. Cottle raised yesterday. And it was agreed this morning at the site visit by those present that it's this plan which shows the alterations, some of which have already come into effect, which is the most accurate one, showing the boundary in the vicinity of the appeal site, not the one at CW 13. So based on that was agreed by all parties, so that's the way I'm treating it. Now those are the points I had to mention on documents. Have I missed anything that anybody's expecting me to raise or to put in?
No, that's very comprehensive. Thank you.
Okay. There was the only other point I want to raise now, before I go straight into closings, is one point which I should have raised during the conditions round table and had intended to, but didn't get around to. And that was in connection with flood risk and whether there should be an additional condition concerning a scheme of possible flood risk measures. If I'm minded to allow the appeals and grant planning permission in a situation where there's recognised flood risk, it's not unusual to ask for a scheme which could include measures, for example, such as tethering tourers, which can be more vulnerable than mobile homes, linking to a flood alert system and having an evacuation plan. And I just wanted to very quickly air that and and just ask for comments from the main parties about the appropriateness, in their view, of such a condition.
Well, obviously it couldn't be linked to a flood alert system because there is no such system for this
Yeah.
area.
But other than that, Mr. Ward?
Other than that, sir, I think given the issues, if you are minded to grant permission, then yes, those details would be helpful in addition to the condition we did discuss about how you deal with the issue of flooding.
Yeah.
So
Okay.
they are what I call the protective measures on site rather than the preventative measures to get rid of the flood water.
Thanks. Mr. Woods, any views?
We'd have no objection to that, so
Thank you
that
very
seems
much.
sensible.
Right, that's all I wanted to raise. Mr. Coughlin?
Just on the point of conditions and out of fairness to my learned friend, what I've done in my closing submissions is I wasn't clear in the condition session if we covered the topic, and it may be because I was reading something else at the time and that you did. But one of the matters during evidence that I was concerned about was whether the area in Appeal Site B used for car parking could be subject to a restriction regarding no built development in order to comply with the buffer zone requirement of the policy NE2. And I wasn't sure that we ventilated that in the condition session, but I'm suggesting in my closing submission, it would be open to you to include that, should
Yes.
you choose to do so. And the other point was
Yeah.
that one of the witnesses, I think it was Mr. Dudley, was very pessimistic about the chances of planting taking root given the ground conditions. And obviously ground conditions change as you move up Appeal Site B. But I've suggested in my closing that if you're having regard to the MPPF and following it diligently as you will, then it's open to you to require in the landscaping some sort of schedule of retention of planting that after 5 years it's replaced. And it's that sort of general condition, so that if the planting fails, what you basically require is deep digging, as I understand it, before you put it in, and it's monitored. And the planting is not just a planting schedule, it's a planting schedule that with belt and braces to make sure it takes, and to make sure it's maintained, and to make sure it's replaced. And it's just a short suggestion of landscaping condition could include something about monitoring and retention and replacement.
Okay.
Well, Inspector, obviously the landscape case has been dealt with by Mr. Dudley.
Yeah.
I don't have him here and I don't have any submissions to make on that. So you'll have to wrestle with that. But I would obviously suggest that anything, if it was suggested different from what was in the evidence, it should have been put to the landscape witness at the time.
Yeah.
Well, with respect, I think we were saying that they would be possible to make sure that the planting took effect with proper measures. And lastly, it appears that I haven't been following the email traffic on the flooding evidence, but that our flooding engineer did present something in response to your questions, but it went further, in my opinion, than what was asked. And so it was probably inappropriate. I don't know whether anything was received by PINS, but there is a shorter box that deals with your questions and only your questions, rather than the other extra material. And it's that which I'm suggesting should now be sent to PINS. And it's just the appellant's response to those questions.
So Inspector, the draft that is in the bundle was sent through on Friday and chased over and over again. And then, throughout Monday, we've been waiting for a response. I mean, it should be easy to say whether or not those factual matters that are in that draft in the ID are agreed or not. It's only giving heights and giving descriptions of what's in there. So I haven't seen anything else, even at this stage. I'm about to make closing submissions. I do object to anything else going in, which is beyond what we've put forward for agreement.
Yeah. I'll come back to that at the end. Right.
So,
check with Mr. Pottle. Mr. Masters, anything else before we get underway? Thank you very much. You nothing else, Mr. Linton?
no, Inspector.
Right, your closing submissions then, please.
Thank you very much, Inspector. As always with these things, it seems a bit artificial to sit and read for such a long period of time. I'll try and make it as interesting as possible. These closing submissions are made on behalf of the Council in respect to 4 appeals, A, B, C and D, relating to applications for 131 and 1 Gypsy Traveller pitches respectively at land north of Lydia Park. I say this is a rare case in which it's possible to state categorically at the outset that the balance of the evidence permits only one outcome. The appellant's cases are founded on a series of remarkable errors, but even when put at its highest, the only possible conclusion is that the appeals should be dismissed. In respect to flooding, the appellant submitted no evidence addressing the new EA flood mapping and called no flooding expert. Initially, they relied upon the case of R Substation Action Limited because the flooding experienced by the sites is surface water flooding, failing to appreciate that, as explained by Mr. Smythe, that case related to an historic version of the framework from July 2021. And indeed, that case was the catalyst for changes made to the flooding section of the framework in December 2024, changes which removed the wording upon which that case was based and inserted into the framework a new paragraph, making it clear that the sequential test does indeed apply to surface water flooding. Despite your providing the opportunity for supplemental evidence addressing these changes, Inspector, the appellants declined to provide evidence addressing paragraph 175 and this significant change or the new flood maps. Furthermore, the appellants plainly were initially, when commencing cross-examination of Mr. Smythe, unaware that paragraph 175, alongside the wording of the framework, required surface water flooding to be treated in the same way as flooding from other sources in relation to vulnerability and flood risk, and the implications this had for the sequential test. Furthermore, when commencing cross-examination, those representing had failed to appreciate the mapping shown on page 7 of Mr. Smythe's rebuttal proof had been superseded. When the inquiry resumed almost a year later, the appellants called Mr. Woods, who conceded quite rightly both that the sequential test was applicable, as with other forms of flooding, and that it was failed in respect of Site A, because this was for a single pitch, necessitating the amendment of paragraph 9.54 of Mr. Woods' proof of evidence as a result. Mr. Rowe, representing Site C and D, failed to appear, but in any event, relied upon Mr. Woods' evidence in respect of flooding. It follows that for the same reasons, the sequential test is failed to Site C and D. In respect of Site B, the consequence of Mr. Woods' acceptance that a site is sequentially preferable if allocated by operation of paragraph 180 of the framework, alongside the fact that 2 DS allocations, 15 and 17, are for 3 pitches or more, means that the sequential test is failed for Site B also. The case should end there. The reality, Inspector, is that on flooding alone, the appeals must be dismissed on the basis that the sequential test has not been passed. Even if it were, the appeals must be dismissed on the basis that the exception test cannot make highly vulnerable development acceptable in an area at high risk of flooding, equivalent in terms of probability of flooding to the functional floodplain. Even if the exception test could be applied, the appeals must be dismissed because the exception test is failed from a technical perspective. The development is both unsafe and makes flooding worse elsewhere. Even were the exception test not failed from a technical perspective, the first limb requires wider community benefits to be demonstrated, whereas the balance of benefit-disbenefit to the community is negative. Leaving all that aside, these appeals could not possibly be allowed in circumstances where the watercourse crossing the sites has been filled, displacing floodwater elsewhere, and the latest EA maps show at least 2 feet of flooding across the sites in the design flood event. But even in the absence of such flood mapping, the effects demonstrated for the 1 in 1.67 year event in and of themselves demonstrate the inherent unsuitability of the appeal sites for the development proposed. The appellant's reliance on conditioning the development to reinstate the watercourse is incomprehensible. In order to impose a condition of the sort suggested, Inspector, you would need to be satisfied both that the FRAs adequately define the extent of the flooding which needed to be addressed. They don't, failing to consider the correct area of land in respect of C and D, failing to appreciate the proposals for Appeal B do not include built development, failing to appreciate that the appeal proposals are not an extension to an existing building, and failing to appreciate that the ditch, which all 4 FRIs insisted must be kept open and free-flowing, had actually already been infilled prior to 2023. And B, that the FRAs provide a viable solution to the identified problem. They could not possibly do this, as the extent of the issue is entirely undefined. There are no details before you, Inspector, as to what would need to be done to address this issue. The situation is made even more hopeless by the suggestion, not found anywhere in the written evidence, that an entirely undefined area of land could be used outside the appeal sites to provide a solution by way of a gramping condition. The fundamental failure of the appellants to address the limitations of the appeal sites for the development proposed extended into the topic of landscape and visual effects. Once more, the appellants failed to call any expert evidence, instead calling Mr. Woods and Mr. Rowe. During cross-examination on landscape matters, it became apparent that not only had neither addressed the issue of valued landscape or impact on the setting of a national landscape, but furthermore, Mr. Woods had no understanding of the definition of a valued landscape or of what was capable of comprising the setting of a national landscape. Furthermore, he had failed to understand the distinction between landscape character effects and visual effects, let alone how these should be addressed, and the importance of professional evidence and transparent evidence when assessing the significance of any impacts. As with flooding, therefore, there are a series of formidable landscape factors rendering the appeal sites fundamentally unsuitable for the development proposed. Not only the sites within the setting of a national landscape, but they've been assessed by Mr. Dudley, an architect of more than 25 years' experience, as performing a key role in separating that landscape from the detracting element of Lydia Park, engaging with paragraph 189 of the framework and RE31, and providing a strong reason to refuse the development proposals. The sites all fall within an AGLV assessed as a landscape valued by both your colleagues, Inspector Willows in the Burnt Hill appeal and Inspector Webb in the land to the north of Grattan Chase. Yet the proposals not only fail to protect and enhance, but cause a high degree of harm. When assessed as the guidance requires, by testing receptors selected following a proper consideration of the LCAs, the proposals are seen to be in conflict with the key positive attributes of this landscape type and in conflict with the landscape strategy. This feeds into another key difficulty with the appellant's case in that it represents development which is inimical to the need for development to be plan-led. Since the time of Sir Ebenezer Howard, the importance of integrating country and city in a planned way have been central to spatial planning. A scrutiny of the DP discloses a carefully structured strategy designed to balance the need to allocate gypsy and traveller sites on the one hand with protecting important public amenity interests, such as landscape and ecological interests, on the other. The strategic policies in the DP provide for development to take place within the countryside in circumstances where the criteria in HN4 are met. The DP includes a series of allocations for gypsy and traveller sites at DS 15 to 20 of the relatively recently adopted LPP2, alongside a windfall policy to cater for additional sites which may come forward during the lifetime of the plan. Fundamental to the operation of HN4 is the need for any proposal coming forward not to have unacceptable impacts on the landscape and to comply with other policies within the plan, which includes policies relating to both flooding and ecology. When considered in the context of this spatial strategy, it's apparent that the proposals before you, Inspector, are wholly different from applications for infill development on the other side of the access track. This difference was recognised by your fellow Inspector Gilbert in determining the appeal at CD 38.8. A Section 78 inquiry process is well suited to determining whether infill development should be permitted to be located within a broad location which is anticipated to be developed. But that is not this case. Should you permit development on the appeal sites, Inspector, it opens the door to development of the wider field to the north of the access track, now named by residents Crocus Lane, stretching towards the national landscape. In reality, you are being asked to form a view on the principle of crossing this track into an area not covered by any allocation, a location which there are a whole range of significant major moderate harms to landscape character and views, including the setting of the national landscape, as well as a range of significant flood-related harms. Whether to take this step is a matter for the development plan process, not a Section 78 inquiry. Lydia Park and its surrounding community is not a location populated by NIMBYs who eschew any development in their backyard. Significant extensive development has been permitted here. What the community requests through the voices of those who attend the inquiry and those who made representations is the right to decide where the development should go in a planned way. This is what the planning system is all about. The gravamen of these considerations is reflected in the targeted representations of those who gave evidence at the inquiry, representing the 4 closest parish councils to the development proposed. When these factors are joined to the harm caused to ecological impact interests by the cavalier approach taken to developing the sites, activities which amount to intentional unauthorised development, clearing the sites of vegetation and covering them with hard standing, the case against appeals is overwhelming. Although the appellants seek to rely upon personal circumstances to justify a personal permission, even significant personal circumstances do not come close to outweighing the identified harms. And in any event, the best interest of the children involved would not be served by remaining on a site because of the location of development proposals, a location which would place those within at high risk of flooding, as well as increasing the flood risk to those in the vicinity. These submissions address the issues in the same order as the evidence was called: landscape, flooding, then ecology, after which there's a section on dominance need, the spatial strategy, and IUD, personal circumstances, and then the planning balance. So first, coming to impact on landscape. A range of factors fall for consideration under the umbrella of landscape. These include the impact on the setting of the national landscape, impact on the valued landscape, as well as impacts on landscape character and views more generally. Mr. Wood's approach to landscape considerations is undermined by a series of factors, Inspector, but the key difference between the parties emerged during his chief and related to his view that the appeal sites were intertwined with Lydia Park. by which he meant that the development existing on the other side of the access track. He felt that Lydia Park operated to reduce the impact the appeal proposals would have on the landscape. The reality, when looked at through the prism of Glavia 3 compliant LVIA, which assessed the development proposals in the context of Lydia Park in a transparent way, is that the presence of Lydia Park serves to increase the importance of the appeal sites as a buffer to the national landscape. This is reflected by the way in which the presence of Lydia Park feeds into consideration of the susceptibility of the landscape to the development proposed, and therefore the sensitivity of the national landscape receptor and the magnitude of change which developing the appeal sites cause to it. Combining these factors results in both a transparent assessment of the significance of impact caused by the proposals and a similarly transparent assessment of how the development performs against the test set out in paragraph 189 to the framework. It follows, Inspector, that the clearest way in which the deficiencies in Mr. Wood's evidence can be demonstrated is in an analysis of how Mr. Dudley has assessed the national landscape receptor. To set the context for this, it's necessary to consider the way in which Glavia 3 requires landscape and visual harm to be assessed. This will demonstrate the reason why Mr. Wood's assessment cannot be relied upon. It will then be seen how the impact on the national landscape through development within its setting has been assessed by Mr. Dudley and why his analysis should be preferred to Mr. Wood's unsubstantiated assertion. Based upon this understanding that to be within the setting of the national landscape, development must adjoin it. It should be noted at the outset that this case represents a paradigm example of the importance of both transparent assessment and expert analysis when determining the significance of landscape effects. So, valued landscape. The framework provides that landscape assessed as a valued landscape should be afforded a special degree of protection under Section 15, conserving and enhancing the national environment. Paragraph 187A provides that planning policies and decisions should contribute to and enhance the natural and local environment by protecting and enhancing valued landscapes. The appellant has offered no commentary within their proofs on whether this is a valued landscape. However, the appeal sites are, as a matter of fact, within an AGLV. They are therefore, by definition, a valued landscape that national planning policy requires to be protected and enhanced. And this conclusion is confirmed by Inspector Willows and Inspector Webb. In his planning evidence on the resumption, Mr. Woods asserted that when the national landscape is extended, the buffer zone may not continue to be an AGLV. However, as Mr. Ward explained, this is only part of the rationale for its protection. The other, its intrinsic value, is unaffected. In any event, the national landscape has yet to be extended, and there is no timetable to change the status of the AGLV. Unless and until this happens, the designation remains in place, as Mr. Woods accepted. Clearly, the proposals do not enhance the valued landscape, nor do they comply with the requirements of policies RE1 and RE32. RE32 in particular emphasises the need to protect and enhance the AGLV in a similar way to the policy approach for the Surrey Hills national landscape. The failure of Mr. Woods and Mr. Rowe to appreciate that the sites lie within a valued landscape is important in and of itself, but also because harm to landscape is assessed by combining sensitivity and magnitude of change to landscape receptors. Sensitivity is assessed by combining the susceptibility of a receptor with its value. So a mistake as to value fundamentally undermines any assessment of landscape character impact. Character. 2.24 of Glavia emphasises the importance of clear and transparent methods, particularly when it comes to assessing how significant a particular change is. The way this is done when assessing character impacts is set out at figure 5.1. Mr. Dudley explained that the starting point to assessing how susceptible the landscape is to the proposed development and which receptors should be used in any assessment is to consider the published character assessments. None of the appellant's proofs reference the published character as set out in Natural England's National Character Assessment or the Surrey Hills LCA. The sites are located within the Low Weald National Character Area. Mr. Dudley explains the sites and their landscape settings are highly representative of the character of the Low Weald, comprising an area of wet and woody countryside. Lydia Park is a detracting element to the south, but the correct baseline position is that it's separated from the national landscape by a wooded stream corridor, serving to filter views. The Surrey LCA places the sites within the Graffham to Dunsfold Wooded Low Weald character area associated with the Wooded Low Weald landscape type. The setting of the sites to the north of Dunsfold Road fall within the Pink Hill to Park Hatch Wooded Low Weald character area. Mr. Dudley has determined the sites and their setting to be moderately representative of the Graffham to Dunsfold Wooded Low Weald character area because of the incongruous influence of Lydia Park, but strongly representative of the Pink Hill to Park Hatch Wooded Low Weald character area. The published LCA of the Graffham to Dunsfold Low Weald character area in which the sites are located describes the landscape as predominantly rural and tranquil. The sites and their setting represent the majority of the key positive landscape attributes of the wooded low-wheeled landscape type. So looking at the approach, Mr. Dudley's had taken an appraisal of the anticipated effects of the appeal schemes upon a range of physical and perceptual attributes of the sites and their setting, in line with nationally accepted guidance. And his list of landscape receptors and their respective baseline sensitivities, once sensitivity of landscape is combined with its value, is as follows: overall character, high sensitivity; immediate presence of Lydia Park, low negligible sensitivity; wider open field to the north, high sensitivity; and relationship with the Surrey Hills national landscape, high sensitivity. His appraisal of effects of the appeal scheme upon the local landscape character demonstrates an extremely high degree of harm. So overall character, major adverse; immediate presence of Lydia Park to the south, moderate to moderate minor adverse; wider open hill to the north, major moderate; wider open field to the north, major adverse; relationship with the Surrey Hills national landscape with appeal A, major moderate adverse; and relationship with that landscape for appeal B, major adverse. It will be apparent from the above assessment that Mr. Dudley has chosen receptors which include not just the site itself, but the relationship with the national landscape. In particular, at paragraphs 4.27 to 4.29, Mr. Dudley's carried out a Glavia 3 compliant transparent assessment of impact on the national landscape, the significance of which will be immediately apparent when paragraph 189 is considered. Landscape effects of the appeal schemes. Mr. Woods has sought to rely upon three approaches to consider landscape character effects and to justify the appeal schemes: the comparison with the recently permitted scheme, the presence of Lydia Park, and the use of vegetation to attempt to hide the developments. All approaches are not correct. Firstly, Mr. Woods has sought to rely upon the comparison with the recent appeal decision at Goring in Oxfordshire to justify the acceptability of the schemes. Mr. Dudley explained that this approach is incorrect because the context of the sites is different, and because the Goring decision was only commenting upon the specific appearance of caravans and mobile homes, and not the wider effects upon the landscape of fundamental land use changes. He relied upon the recent decision of Inspector Pleasant, which recognises the importance of assessing the impact of gypsy and traveller pitches upon the specific character of the rural landscapes within which the development sits, with reference to the relevant LCA, and the ineffectiveness of planting schemes in mitigating landscape impacts. Furthermore, the overall strategy for the wooded low-wheeled landscape type is set out in the LCA, advising limiting the spread of settlements and other developments. Secondly, Mr. Woods relied upon the presence of Lydia Park to justify the creation of more gypsy and traveller pitches in this location. But Mr. Dudley explained that this approach is incorrect because, as explained above, Inspector Willows in his recent decision has stated this is a valued landscape irrespective of the presence of gypsy and traveller land uses, and therefore the requirement to protect and enhance remains valid. In any event, the correct approach is to identify Lydia Park as a receptor to the wider consideration of landscape effects, and the sites play an important role in separating Lydia Park from the national landscape. Thirdly, Mr. Woods has erroneously narrowed the matter of character and appearance to the visibility of sites, but this does not take account of the requirement to consider the effects upon the landscape as a resource in its own right, which is fundamental to the consideration of impacts upon the AGLV and upon the setting of the national landscape. Finally, Mr. Woods relies upon planting schemes to mitigate views towards the appeal schemes, but as set out in Mr. Dudley's evidence, the ground conditions have been adversely affected by the IUD of the sites to the extent that these schemes are highly unlikely to successfully establish. This is evidenced in the extensive mortality of trees in the plot of land between appeal A and B sites, and the severe decline of one of the mature trees in the appeal A site. Landscape effects, appeals C and D. Mr. Rowe has failed to apply the correct methodology in the consideration of landscape and visual effects. He's relied upon two incorrect approaches to justify the appeal schemes: comparison with a recently granted permission for a light industrial scheme at Thatched House Farm to the west of the site, and the imposition of a condition for a landscaping scheme. Mr. Dudley explained that Mr. Rowe is wrong to compare the appeal schemes with light industrial schemes because these are fundamentally different land uses, and as such their character and appearance is fundamentally different. The flaw in this approach was apparent during Mr. Rowe's evidence, during which he noted that when walking past this scheme, one would not realise these buildings were not in agricultural use unless one was aware of the permission. This is exactly why this scheme does not cause the same high degree of harm as the appeal schemes. Agricultural buildings are not incompatible with the LCA within which the sites sit. Such a comment only serves to emphasise the importance of undertaking a careful assessment of the LCAs as part of an assessment of landscape character impacts. Secondly, Mr. Rowe incorrectly relies upon the potential to impose planting conditions to make the appeal schemes acceptable. This is a flawed approach because, as Inspector Pleasant has determined in the Peasdale appeal, planting does not address the fundamental harm to the character of the landscape in rural locations. Mr. Dudley has also explained that Mr. Rose failed to adequately recognise the visibility of the sites both within the national landscape and on its boundary, and the effect of introducing artificially small and geometric enclosures. In any case, the intentional unauthorised development has, as with appeals A and B, damaged the ground conditions to the extent Mr. Dudley considers planting unlikely to establish. In relation to visual environment, in the case of appeal sites B to D, Mr. Dudley is undertaking a structured and transparent assessment of the effects of the appeal schemes upon those who would view the sites from public locations in line with guidance. By comparison, Mr. Rowe has not undertaken any form of appropriate assessment. The only visual receptor identified by him is from Dunsfold Road. He relies upon an image taken from a Google Street View, does not follow the required steps in assessing impact. He's failed to recognise the visibility of the schemes from public footpaths within the Surrey Hills national landscape. Mr. Dudley's list of identified visual receptors and their respective baseline sensitivities is as follows. Footpath 279, very high sensitivity. 277, very high sensitivity. Users of Dunsfold Road, medium sensitivity. His appraisal of the effects of the appeal scheme upon those receptors concluded footpath 279, major moderate adverse. Footpath 277, major adverse. Users of Dunsfold Road, major moderate adverse. Subsequent to Mr. Dudley's original assessment, a collection of winter views were taken by the council, which have confirmed that appeal site A is visible from public footpath Bramley 277 within the Surrey Hills national landscape in winter months, giving rise to adverse effects of major moderate significance. The winter survey also revealed that appeal sites B, C and D are visible from public footpath 533, giving rise to an adverse effect of major moderate significance. Mr. Dudley explained that the intentional unauthorised development upon the site has resulted in extensive damage to ground conditions to the extent he doesn't consider screening would be established. In any case, he explained that this would introduce artificial geometric shapes. So the National Landscape Inspector, when delivering his landscape evidence, Mr. Woods asserted and maintained in the questions from yourself that the site could not be within the setting of a national landscape unless it was adjacent to it. This is obviously wrong and only serves to emphasise that Mr. Woods' judgment can be given no weight when it comes to landscape matters. Mr. Woods was in any event immediately contradicted by Mr. Rowe, who confirmed that in his view, the sites were within the setting of the national landscape. It was suggested in questions of Mr. Ward that he was incorrect to give the harm to the setting of the national landscape great weight, and implied that he was not correct to conclude that the impact constituted a strong reason to refuse permission in footnote 7 terms, should paragraph 11D be engaged by paragraph 28 PPTS. However, Mr. Ward plainly was correct to conclude, basing his view on the transparent evidence of Mr. Dudley, who has the necessary qualifications to carry out an assessment of such landscape harm. The framework provides at 189 that development within the setting of a national landscape should be sensitively located and designed to avoid or minimise adverse effects on that landscape. 189 is a footnote 7 policy in that it provides a strong reason why development across those sites should be refused. The gravamen of Mr. Dudley's reasoning on this issue is to be found within paragraphs 4.27 to 9 and the corresponding paragraphs within the proofs relating to those sites. Having cited the test, he concluded the statutory AONB management plan requires development within the national landscape setting to enhance local character and the environmental quality. The alignment of the site perpendicular to the existing Lydia Park boundary means that the separation between the residential, gypsy and traveller uses and the national landscape would be substantially reduced in relation to B to D from 300 metres to approximately 160 metres. The proposed development would project an incongruous and intensive land use toward the national landscape that's anticipated to result in harm to the character of its setting. It would replace an area of naturalistic woodland and overgrown hedgerow that assist in the separation of Lydia Park and the national landscape with a domestic land use that's not sensitively located or designed, and the existing unauthorised development represents a less sensitive approach. Mr. Dudley's figure 5 above demonstrates there's a clear visual relationship between the site and the national landscape, which is likely to be greater in winter months. Taking these factors into account, the magnitude of change upon this receptor is judged to be high. The proposed development is therefore judged to result in an adverse impact of major significance. Given Mr. Dudley's conclusion the sites are not sensitively located or designed, and that there would be an adverse impact of major significance of effect on the national landscape as a receptor, Mr. Ward's conclusion there would be great harm to the national landscape in respect of each pitch, and this would constitute a strong reason to refuse permission, is to be preferred to any assertion of Mr. Rowe to the contrary. Mr. Wood's assertion, having accepted that paragraph 189 contained the policy on national landscape, that footnote 7 did not apply to development unless it was within a national landscape, despite 11D1 referring to the application of policies in this framework that protect areas or assets of particular importance, and footnote 7 saying that the policies referred to are those in this framework relating to a national landscape, was incomprehensible. Cumulative effects. In addition to the individual judgments for each scheme, Mr Dudley has identified the potential for cumulative adverse effects if more than one scheme is delivered. This judgment is supported by the A1B management plan, which emphasises the importance of this nationally important setting in its overall aim and notes the cumulative effects of many, often small developments over decades and centuries would reduce the landscape and scenic beauty of the Surrey Hills and spoil it for future generations. Mr Dudley expresses the view that the approval of multiple pitches would lead to the cumulative erosion of the character of the setting through the creation of a greater incongruous settlement mass and a reduction in the tranquility and scenic value. Plainly, the very high level of landscape harm, alongside the other harms identified through the evidence, should result in the dismissing of the appeals individually. But even were that not the case, Mr Ward explains that the pound stretcher principle would be engaged, as discussed in relation to gypsy and traveller sites by Lindblom QC, then sitting as a Deputy High Court Judge in Tracy Holland. In these paragraphs, which relate to a field split into a number of gypsy plots, it is explained that an inspector had lawfully concluded that although any single proposal coming after a previous one, on which had not been found unacceptable, would not necessarily be unacceptable in itself, ultimately, and this would depend upon the particular conclusion under consideration, be it highway or landscape impact, the time would come when there was an acceptable harm. This was an acceptable basis on which to refuse permission, even should it be found that an individual site was not harmful to the landscape. In the present case, it's submitted that Mr Ward is correct to consider the precedent effect to be of greater concern as the sites are situated within a valued landscape and within the setting of the national landscape. Should it be relevant, as he explains, the appeal should be dismissed on this basis also. It follows that the landscape proposal would cause very great harm to landscape character and views. They would fail to protect and enhance an AGLV, in conflict both with the provisions in DP Policy RE3 and the framework. Moreover, the proposals are not sensitively located nor designed to minimise the impact on the national landscape. Given the conclusions of Mr Dudley and the inclusion of the national landscape as a receptor against which he's assessed the impact of the appeal schemes for each pitch, this represents conflict with 189 of the framework, to which great weight should be attached. It also constitutes a strong reason to refuse permission, should the provisions of paragraph 11D be engaged by the lack of a 5-year supply. In respect to flooding, there's a large measure of agreement following the conclusion of the flooding evidence, which can be summarised, Inspector, as follows. On the sequential test, it's agreed that the sequential test is applicable. It is agreed the sequential test is failed for Site A, and the same reasoning applies to Sites C and D. It is agreed that although Table 2 of the PPG is not framed in surface water terms, the exception test can be required even for surface water flooding because the development is highly vulnerable development. On the FRAs, the under FRA covering sites B, C and D in respect of each site was based upon an incorrect site location plan, there being no ground raising on site when there has been, an incorrect understanding that the proposed site is for a minor extension to existing property such that safe access and escape is not required, and the drainage ditch being kept clear of any vegetation or debris to ensure its continual free flowing, but this ditch has been filled. The Flume FRA covering Site A was based upon a proposal consisting of buildings which will be raised on skids, and the stipulation that regular maintenance of any drains and culverts surrounding the site under the riparian ownership of the developer should be undertaken to reduce flood risk. Neither FRA discusses flood warning or flood alert as part of an evacuation plan because these options are not available for the appeal sites. On the flood models, the latest EA flood mapping has a base date of 2019 for the LiDAR and 2025 for the latest modelling software, as well as the water and rainfall patterns. Whereas in respect of UK Flood Map 4, relied upon only in the Flume FRA, being dated 2023, it is not known whether it used the 2019 or 2022 LiDAR, but it did not have access to the later water and rainfall pattern information. The latest flood depth information shows up to 600 millimetres of floodwater across sites C and D in the design flood, and up to 900 millimetres across sites A and B. On enforcement action has been taken in respect of sites C and D. Mr Woods agrees that enforcement action can be taken against the development on sites A and B also. In respect, Inspector, of the sequential test, the sequential test is failed for Site A. It's also failed for Sites C and D. This is because Mr Woods accepted that there were sequentially preferable allocated sites which could accommodate a single pitch. He amended paragraph 9.54 of his proof of evidence to reflect this. His firm has already obtained permission for the gypsies and traveller pitches allocated in DS18 and DS20, so these could not be occupied by the appellants in the present appeals. However, others remain, including DS19 for 2 pitches. The best evidence is that the sequential test is also failed for site B. Although Mr. Simon Doherty in oral evidence said that it made it easier to have his older sons and their family close by, he expressly stated that he would definitely stay, even without these family connections. The context of your previous question, Inspector, making clear that family connections referred to were those of his sons. The consequence of this is that in reality, the sequential test for Appeal B should be done on the basis that the use can be split into 2 or more smaller sites. On this basis, it's common ground, the test is failed. But even if you were of the view, Inspector, that the appropriate search criteria should be for 3 pitches to keep the extended family on site B together, the test is still failed because there are sequentially preferable allocated sites for 3 pitches, and Mr. Wood's site search reveals sequentially preferable sites. In respect of allocated sites, Mr. Smith explained that the allocated sites are by definition sequentially preferable to site B. This is by operation of paragraph 180 of the framework, which provides where planning applications come forward on sites allocated in the development plan through the sequential test, applicants need not apply the sequential test again. There are 3 DS sites which offer multiple pitches, 15, 17 and 19. DS 19 is only allocated for 2 pitches, but 15 and 17 are for 5. 15 is for 3, sorry, and 17 is for 5. Mr. Wood's only reason for discounting DS 15 and 17 is because of his view that to be sequentially preferable, the site must not be at risk of flooding from any source. But with respect to him, this is plainly not correct, even on the basis of his own answers in cross-examination. First, Mr. Woods accepted that these sites were by operation of paragraph 180 sequentially preferable, but said there were other factors to be considered. However, paragraph 180 states that if a site is allocated, applicants do not need to apply the sequential test again. It is agreed that the sequential test must include flooding matters. The issue in dispute between the parties is whether suitability considerations go beyond flooding. This means that DS 15 and 17 must be sequentially preferable when it comes to flooding by operation of paragraph 180. To hold otherwise would deprive the paragraph and allocations of any real meaning. Second, and in any event, even ignoring the operation of paragraph 180 and the fact that flooding considerations have been expressly considered in their allocation, DS 15 is sequentially preferable in terms of flooding. This is because Mr. Woods notes that 1, only parts of it are at low to medium risk. Mr. Smythe points out that this should actually be low risk of surface water flooding, whereas parts of the appeal sites are at high risk of surface water flooding. And 2, the extent of flooding is much less on DS 15. This engages with the appeal decision that Mr. Smythe included in Appendix B to his rebuttal and quoted from it is 2.15. Whilst both sites could have the same flood risk, one site may be subject to a lesser area of flood risk, and thus it could be sequentially preferable. On the same basis, Mr. Smythe explained that DS 17 is sequentially preferable by virtue of its being an allocated site, but even if it were not allocated, it may be sequentially preferable in any event when one considers the percentage of the site which will be subject to flood risk. To this would be added the fact that DS 17 is only subject to low rather than high risk of surface water flooding. Mr. Woods has simply not engaged with these principles. He suggested in cross-examination that the allocations didn't take into account the new March 2025 EA mapping, but even if one performs a like-for-like comparison using the old mapping, 15 and 17 are sequentially preferable, both by operation of paragraph 180 in any event, and because one or both of the extent and category of flooding is less on those sites when applying the older mapping. This means that Mr. Woods has not shown the sequential test to be passed for site B on the basis of the allocated sites. For completeness, Inspector, there are sites within his search which are also, on the face of it, sequentially preferable. His site too is ruled out solely on the basis it is across the border in the adjoining local authority. But as Mr. Smythe explained, Mr. Woods has not approached the council to define the appropriate area of search for those sites, something flagged as important by the inspector in Mr. Smythe's Appendix B. And given their location, 15 to 20 kilometres from the allocated sites, which Mr. Woods accepted should be considered, and given the key determinant discussed by the appellants was their links to Lydia Park and services in the surrounding area, there is no basis to exclude sites also within a 30-minute drive, but just over the border, only 6 kilometres away. His site 3 is ruled out, but the reasons are not explained in his page 54 table. Orally, he claimed there were other non-flooding suitability factors applicable to this site, but accepted that other lots had been purchased. Mr. Smythe explained that Culmer Lane is sequentially preferable. Inspector Hand's decision from Cufford Lane, provided in his Appendix A and discussed at 2.5 as rebuttal, is clear. The proper interpretation of the sequential test is that it rules out sites on the basis that, as a site is unlawful, there are lots of other sites, just as unlawful, but better located in terms of flooding, which should be considered first. This means that suitability of available sites for the sequential test should be confined to flooding considerations, with other planning issues being considered only after it has been demonstrated that the sequential test has been passed. His Site 1 is also ruled out principally due to greenbelt concerns, but once again, in his justification, Mr. Woods conflates the Angela Smith Authority, which he relies upon in relation to whether weight should be given in a planning balance to the lack of suitable available sites, with the sequential test, which is concerned with suitability from a flooding perspective. It follows for all of the above reasons that Mr. Woods has not demonstrated the sequential test is passed for appeal site A or B. By the same logic, the sequential test is also failed for C and D, Inspector. The case should end there. There are extremely strong policy considerations which operate to preclude the grant of permission where the sequential test is failed. Paragraph 177 of the framework is clear that one only moves on to consider the exception test once the sequential test has been passed. Failure of the sequential test obviously provides a strong reason for refusing permission, disapplying the tilted balance, even if one arrived at a situation after considering need where paragraph 11D had been engaged. Exception test. It's common ground that although table 2 of the PPG is not framed in surface water terms, the exception test can be required even for surface water flooding because the development is highly vulnerable development. This is clear from Mr. Woods' proof of evidence paragraph 9.55. Furthermore, Mr. Woods confirmed orally that his view was that the exception test is required as set out in paragraph 9.55. So that you can be confident in how you set the matter out in your decision, Mr. Smythe explained in answer to your questions and in writing the way in which his industry interpret how Table 2 of the PPG must be applied in order to be consistent across all forms of flooding. Paragraph 177 of the framework provides that the need for the exception test will depend on the potential vulnerability of the site and of the development proposed in line with the flood risk vulnerability classification set out in Annex 3. Annex 3 provides the flood risk vulnerability classification for caravans, mobile homes and park homes intended for permanent residential use is highly vulnerable. The flooding PPG 023 provides that other forms of flooding need to be treated consistently with river and tidal flooding in mapping probability and assessing vulnerability. PPG Table 2 assessing vulnerability provides that highly vulnerable development should not be permitted within flood zones 3A and B, which represents a flooding probability of either 1 in 100 years or 1 in 30 years, as explained in Table 1. In order to treat surface water flooding equally with tidal and river flooding in mapping probability and assessing vulnerability, as required by PPG 023 and paragraph 177 of the framework, the same approach should be taken to a site with an equivalent probability of surface water flooding to river flooding when dealing with highly vulnerable development. For surface water flooding, a flooding probability of 1 in 100 years equates to a medium risk of flooding, and a probability of 1 in 30 years equates to a high risk of surface water flooding, ID 23. In respect of both medium and high, development should not be permitted because there is a cross in the relevant box in Table 2, and the key provides that development should not be permitted. Mr. Woods' proof of evidence addressed only the EA mapping replaced in January 2025, and he proceeded on the basis that the exception test was required because he interpreted that mapping is showing the appeal sites to be at low risk of surface water flooding. A low risk of surface water flooding equates to flood zone 2 in Table 2 because flood zone 2 relates to 1 in 1,000 probability of flooding event, applying Table 1 of the PPG. This was not in fact a correct reading of the previous flood mapping because, as can be seen in the comparative maps in Mr. Smythe's evidence, even the now superseded mapping had some elements of medium flooding across sites A, C and D. The consequence of the sites now being in an area of high risk of surface water flooding means that the same logic Mr. Woods employed in his paragraph 9.55 should result in the development not being permitted with the exception test not to be applied. This is because the table provides that such highly vulnerable development should not be permitted in an area at such a high risk of surface water flooding when treated consistently with fluvial flooding. If, Inspector, you have not already dismissed the appeals because the sequential test has been failed, the appeal should be dismissed on the basis of this instruction in Table 2. However, if one goes on to apply the exception test, then both elements must be satisfied for development to be permitted. When these two elements are scrutinised, it is obvious they are not passed for these appeals. The two elements are the development will provide wider sustainability benefits to the community which outweigh the flood risk, and the development will be safe for its lifetime, taking into account the vulnerability of its users without increasing flood risk elsewhere, and where possible, reduce flood risk overall. Development not demonstrated to be safe for its lifetime, taking into account the vulnerability of its users. The flood maps produced by the Environment Agency, risk of surface water flooding, were updated in January 2025 and now show more flooding in the appeal site areas. These current flood maps are shown in Mr. Smythe's supplemental evidence and show a high risk of surface water flooding across these appeal sites. On page 6 and 7, the new flood maps can be compared with the old maps. These current ROSWF maps were issued 28th January 2025 and represent the latest surface water flood modelling information produced by the Environment Agency. The current updated mapping models show how water flows in ponds. Mr. Smythe explained that the latest mapping was produced from topographical information, rainfall patterns, historical flood records, and enhanced using locally produced flood modelling from the appropriate LLFA. The new mapping is an advancement over the old mapping, which is now considered superseded. High-risk flood areas are shown across appeal sites A to D. Mr. Smythe explained that the high-risk flood areas are modelled on the original pre-development landform, EA data based on 2019 LiDAR and more accurate surface grid. He noticed that the land raising and culverting works undertaken as part of the development would have worsened the flood extents area, which has modified and restricted the operation of the watercourse. Mr. Smythe noted in Figure 8 of Flume FRA, an additional flood map is presented as more detailed Flood Map 4 flood modelling information, which it is claimed shows no flooding on the appeal site A. No such claim is made for sites B to D, as under adopts the EA flood mapping. Mr. Smythe noted that in his professional view, this mapping was not reliable as demonstrating the true extent of likely flooding for many reasons. This Flood Map 4 model from 2023 would not have had access to the latest rainfall patterns and historical data, including locally produced modelling from the appropriate LLFA, something EA mapping from 2025 includes. This simple factor makes the UK Flood Map FRA from 2023 unfit for purpose in the light of the new EA mapping. Page 10 of the Flume FRA states that models of this type tend to perform, that's EA-RAO-SWF, tend to perform better in steeper, more rural sites than in flat urban sites. This site is rural and the catchment has steep sections of landform, making the EA mapping the more reliable option. The ground levels used for the UK Flood Map 4 are also unclear. It's not known if this is pre or post development and therefore cannot be taken as representative. Following the evidence from the appellant himself, it seems probable that although the Flume FRA was based upon the need to regularly maintain the drain to reduce flood risk, this drain was in fact infilled prior to the date of the FRA. As no other drain is shown in Figure 1, this calls into question whether the author of the FRA had visited the site and appreciated what had happened to the drain. All modelling and flood mapping contain uncertainty and assumptions, but in this case, you, Inspector, have the benefit of the November 2024 flood event presented in Mr. Smythe's supplemental evidence, which was calculated to be the 1 in 1.67 year rainfall event based on local DEFRA rainfall gauging station. Council inspection photographs from the following morning showed relatively severe flooding, indicative of the current 1 in 30 high-risk flood mapping extents for just the 1 in 1.67 year rainfall event, with floodwater depths of 300 millimetres noted around the appeal site areas. Mr. Smythe concluded that this made it clear to him that the development is at risk of flooding. Based on these 4 points, Mr. Smythe concluded that the Flood Map 4 information cannot be relied upon to inform this development. To this can be added the fact that, as made clear in your questions of Mr. Woods, the Flume FRA is also based upon the incorrect assumption that the development is for buildings which can be raised on skids. This is such a fundamental error that it calls into question whether the FRA is even considering the correct application site and development, and is another reason why it cannot be relied upon. Mr. Smythe therefore concludes that the most appropriate mapping to use for the assessment of the appeal development site is the current EA surface water flood maps. At your request, the flooding depths across the sites have been provided, and they show up to 600 millimetres of flood water across sites C and D in the design flood event, and up to 900 millimetres across sites A and B. These levels come right across the centre of Site A and form a wide area of deep floodwater separating sites B and D from access to Crocus Lane, trapping the occupants on site in the design flood event. Mr. Smythe expressly considered that a strategy of anchoring caravans with chains and raising them up to 300 millimetres above ground level, suggested in the under FRA, to be inadequate as a measure to protect life and property, with the FRIs providing no assessment of floodwater depth and velocity. The implications of this are made worse by the fact that, as Mr. Woods confirmed, the occupants of the sites would not have access to any flood alert or flood warning programme. Furthermore, if personal circumstances are relied upon, the sites are proposed for occupants, which include those with significant medical needs. Evidence was given by the occupants of sites A and B that these sites include the need for regular access to and from the hospital and an elevated level of medical support. Against this background, it is hopeless to suggest that it has been demonstrated that the development will be safe for its lifetime, taking into account the vulnerability of its users. The reality is that on the best evidence, the opposite is demonstrated. The site will be unsafe. The development makes flood risk worse elsewhere. The framework makes it clear that the exception test can only be passed if the development does not increase flood risk elsewhere, but the development does just that. Mr. Smythe explained that appeal sites A to D originally consisted of an open, unpaved, agricultural, partly wooded land, referred to in drainage terms as greenfield. The land was undeveloped and rural in nature. The sites included an ordinary watercourse, which conveyed surface water from a large established pond to the west by Thatched Cottage Farm, flowing through all 4 appeal sites, and ultimately discharged water to Cobbler's Brook, and from there flows into the River Arun. He further explained that the ordinary watercourse is consistent with surface water flood mapping produced by the EA. This mapping shows flooding along the route of the watercourse, which is located north of the Lydia Park Access Road, and which is land at lower level than the Lydia Park Access Road. In the mapping plans, when the watercourse is overwhelmed in times of more extreme rainfall, the land north of the access track is shown to flood. The appeal sites are located along the route of this surface water flooding corridor. As already noted, the current EA flood maps are based on LiDAR from 2019 and use more powerful and accurate modelling technology. Mr. Smythe concluded, based on this, that this flood mapping is modelled on the basis of an open watercourse flowing through these areas. Plainly, his professional view is correct. Mr. Smythe explained that the development on all 4 appeal sites includes hard surface paving and land raising earthworks to form development platforms for the siting of caravans and mobile homes. The greenfield natural soil has been removed or covered over with macadam or compact granular materials, such that hard standing has been formed. The development surface is different to the pre-development surface, as vegetated topsoil is no longer explained to rainfall, and hard standing or macadam prevent water soaking through the top surface. Instead, water tends to flow over the surface as surface flow. The ordinary watercourse has been infilled as part of the development, and he noted from his site visit that a piped culvert has been installed along the route of the ordinary watercourse. Although both the Flume and under FRAs note the presence of the ordinary watercourse within the respective documentation, Mr. Smythe explained that the modified ground levels resultant from the development were not defined by survey information, and any land raising in the area at risk of flooding will push floodwater elsewhere, increasing flood risk to others. Normally, a pre-development topographic survey would be provided to understand the topography and inform the levels design of development. This information has not been provided, and the associated risk cannot be determined accurately without such information. In terms of reduced flow capacity, Mr. Smythe explained that the flooding shown in supplementary information is likely to be worsened by the development works, as the installed pipe has a far lower flow capacity than the pre-development ordinary watercourse. His proof outlines the basis for hydraulic calculation, which is presented in Appendix 11. This shows there is a 91% reduction associated with the culverted pipe rather than watercourse. This equates to the displacement of more than 700 cubic litres of water, or almost 3/4 of a tonne, per second along each metre of the ditch. The pipe will significantly restrict the flow of water compared to the pre-development watercourse, and there will be a greater extent of surface water flooding post-development as a result of this loss of conveyance capacity. Mr. Smythe notes that this worsening effect of surface water flooding is not defined in the applicant information because the development levels, land raising and culverting have not been assessed. Such information and analysis would normally occur as part of a planning application or an ordinary watercourse consent process. So what are the consequences of that? Well, Mr. Smythe explained that without this assessment of culvert flow and associated flood extent, flood depth and floodwater velocity, it is not only impossible to define the flood risk to the occupants, but it is also impossible to define the flood impact of the development elsewhere, and that the surrounding community also contains highly vulnerable development. Mr. Smythe's professional opinion is that the watercourse previously drained approximately 150 metres of the Lydia Park Access Road, which also drained the surrounding fields and surrounding Caravan Park. The water does not appear able now to reach the watercourse since it's been infilled, and there are no road gullies and limited drainage inlets noted on the site visit. Hence, the surrounding area does not now drain effectively. He concluded that the 1.167-year event, which approximates the yearly flood risk, would previously have been contained within the ditch. Post-development surface water overland flooding is likely resultant in times of heavy rainfall. which also increases flood risk elsewhere, particularly the Lydia Park access track, impeding safe access. He explained this view is confirmed by photographs of the November 2024 rainfall event, which show flooding of the access track and the area around the appeal sites. He also noted that the consequence of raising levels across the sites in areas impacted by surface water flooding is that this will change the flooding behaviour. Put simply, if the valley area of the watercourse is raised up in level, then the floodwater volume that would normally occupy the valley floor and watercourse will be displaced, and the floodwater will find a different area to accommodate the same volume of water. This has increased flood risk elsewhere. Irrespective of the exception test, any development must be shown to be safe and not to make flooding worse elsewhere. The appeal proposals are a textbook case on what should not be permitted. Development where the best evidence clearly demonstrates both that the occupants are unsafe and that flooding has been made worse elsewhere. Suggested condition. Mr. Wood suggested a condition to address flood risk, perhaps resulting in the reinstatement of the lost watercourse, perhaps resulting in off-site works. This suggestion is fundamentally flawed for many reasons. As a matter of substance, it is flawed because even if the watercourse were reinstated, the latest flood mapping based upon the latest rainfall projections and the 2019 LiDAR shows a band of high-risk flooding across the appeal sites. Reinstating the watercourse would simply result in the appeal sites remaining within this high band of high surface water flood risk. In relation to all the sites, this high-risk flooding precludes safe access and egress for those with elevated health concerns during the design flood event with depths of 2 or 3 feet. For Site A, the entirety of the area upon which the caravans are proposed to be sited would be under up to 3 feet of water in the design flood. In any event, any condition, including Grampian condition, can only be imposed if necessary, precise and reasonable, which means that the decision maker must be presented with information accurately describing the extent of the problem and the details of its proposed solution before a condition can be imposed. In Mr. Smythe's words, it must be demonstrated that any proposed solution is viable in advance of imposing a condition. What this means in practice was explained by Inspector Murray in the Loddington appeal. Before a condition is imposed, the documentation before you, Inspector, must accurately demonstrate the extent of the problem and what it proposes to address. No such information exists in this case. In fact, in the present case, the flooding documentation relied upon is demonstrably flawed in a whole series of ways, as described above at 59D to G, such that it cannot be relied upon even to show that the correct appeal sites and correct development have been assessed, let alone that the extent of any flooding has been understood. Neither FRI proposed any solution as it doesn't recognise the problem, not assessing the correct topography or latest rainfall patterns and historic data. Against that background, the suggestion that a Grampian condition relating to off-site works could be imposed verges on an absurdity. The FRIs do not identify what area of land may be necessary for any works, and Mr. Woods gives no information about this. There is no evidence that whoever may own any off-site land would agree to any such undefined works, or whether, even if those works were undertaken, they are informed by the full extent of any problem. Indeed, the best evidence before you, Inspector, is that they positively would not be. Even less could it be said to have been demonstrated that it is possible to address any undefined issues. In fact, given the evidence heard at the inquiry relating to the extent of high-risk areas shown by the latest flood mapping, again, the best evidence is it would not be. Furthermore, Mr. Smythe has provided evidence both on the theoretical suggestion by Mr. Woods that the watercourse may be reinstated with new piping, and the equally theoretical suggestion that a basin of some kind could be employed, showing that neither solution is likely to be practical or possible for the quantities of water involved shown in the latest mapping. In respect to Mr. Rowe's assertion that the existing drainage mechanism of infiltration is not significantly changed by the development, Mr. Smythe explains that the ground conditions include a bedrock of clay subsoil, which is not suited to soakage solutions, and Mr. Rowe's assumption is simply incorrect. Surface water cannot soak into the surface, that is clay already highly saturated with groundwater close to the surface. For this site, providing drainage design outside the low-risk flooding area, excluding any soakage solution, will limit the available solutions. And from a review of the applicable information, Mr. Smythe concluded that he cannot see how this could be shown viable. Any suggestion of benefit arising from the imposition of a condition is also hopelessly misconceived. Mr. Woods accepted that enforcement action could be taken in respect of the appeal development. Notices have already been served on sites C and D. This is equally true for any operational development which has taken place off-site. For any and all of these reasons, a condition could not be imposed addressing flood risk. Wider community benefits. Finally, in respect of wider community benefits, Mr. Ward explained that these should be substantive in nature, using the examples in PPG 036 to describe the kind of benefits envisaged by the guidance. He also explained that to determine whether such benefits exist, it is necessary to look at both benefits and disbenefits to the community and take an overall view on whether any benefits are positive, neutral or negative. It is suggested by Mr. Woods that there is a wider public benefit which could be served by allowing the appeal site development to remain, namely the site occupants would not need to resort to roadside camping, which benefits the wider community. However, any such benefits are not substantive, and on any sensible assessment would not amount to overall positive community benefits once the community benefit of the increased flooding to Crocus Lane, disbenefit of the increased flooding to Crocus Lane is taken into account. The list in paragraph 036 also makes clear that community benefits are not limited to solely flooding considerations. The appeal proposals would also result in many community disbenefits if allowed to remain, such as those relating to impact on the public's enjoyment of the landscape, including the national landscape, and their ability to appreciate an intact biodiversity-rich environment across the appeal sites. When these disbenefits are added, any resultant balance in terms of wider community benefits is negative rather than positive. Even if wider community benefits existed, the next step will be to weigh any such benefits against the flood risk to see whether any such risk is outweighed. When the risks to both on-site and off-site are taken into account, it cannot sensibly be maintained that these substantial risks are outweighed. It follows that this part of the exception test is also failed. So to conclude, the sequential test is failed for all sites. The appeal should be dismissed on that basis. For highly vulnerable development at risk of flooding, high risk of flooding, the exception test cannot be applied, and in accordance with Table 2, the appeal should be dismissed on that basis. Were the exception test to be applied, it is failed, both because of the flood risk and the fact that flooding is made worse elsewhere, and because there are no wider community benefits which outweigh the flood risk. So, ecology inspector. So, the appellant's position is not that there will be no harm to ecology, but that any harm is less than that contended for by Mr. Sibbett. As with landscape and flooding, however, their case is flawed. It's flawed for these principal reasons. Mr. Sibbett is an experienced ecologist of more than 30 years. He's analysed the ecological reports submitted and identified a whole series of areas in which significantly harmful impacts have been caused to habitat and species, including a failure to carry out the necessary surveys to identify the nature and degree of impact on species which the development of sites has caused. Where his view differs from that of Mr. Woods, it should be preferred. The appellant's assertion that the baseline for the sites was post-works was unexplained, incomprehensible, and directly contrary to Mr. Woods' acceptance in answer to your questions, Inspector, that enforcement action could be taken in respect of the use and associated operational development on the sites. Indeed, such notices have been served on sites C and D. This stance is also contradicted by the baseline taken in the more detailed Arbtech report for Site A. The ecological reports for sites B to D failed to appreciate the true pre-development situation on those sites and failed to identify any of the principal harms. None of the reports appreciated that a watercourse had existed on the sites pre-development, and accordingly this was not assessed. And the appeal site development has resulted in each case in the habitat and species across the entire site area being lost. The policy, NE1, doesn't provide for compensation. Mr. Woods made it clear in cross-examination he didn't understand the difference between mitigation and compensation. But even if it did, Mr. Sibbett explained that such on-site mitigation as is suggested by Mr. Woods couldn't address the scale of habitat and dependent species which have been lost. So looking at appeal site A in terms of habitats and species pre-development, in terms of habitat, the table on page 16 of the preliminary ecological appraisal notes the site formerly contained deciduous woodland habitat of principal importance under 41 of the NERC Act. In his proof, Mr. Sibbett concluded that baseline habitats present were deciduous woodland being a priority habitat and a watercourse in the form of a ditch. In terms of species, the table, page 17 of the assessment, lists species or groups which may have been present, including protected or notable plant species, great crested newts, bats roosting, foraging and commuting, badgers, invertebrates, great crested newts, reptiles, breeding birds and hedgehogs. The Darwin letter dated 15th January 2024 agrees with Arbtech's PIA on its second page, third paragraph, noting woodland habitat surrounding the site and the woodland habitat of the pre-development site has moderate to high intrinsic ecological value and offers good opportunities for protected and notable species. To this, Mr. Sibbett added that the pond which Arbtech had requested to be surveyed had not in fact been surveyed, something with which Mr. Woods agreed. Mr. Sibbett expressed the view that 4 years was more than enough time for great crested newts to have colonised the pond adjacent to Site A on either side, relying on the dicta of Inspector Willows in the Burnt Hill decision, and that the woodland provided shelter to adjacent habitat, making the adjacent habitat more suitable for the wood white butterfly. In respect of B to D in terms of habitat, in respect of each site, the author of the report has failed to appreciate the undeveloped nature of the sites, simply recording habitats recorded within the development boundary comprised of hard standing, improved grassland and a mobile home. Whereas Mr. Sibbett explained that the habitat on sites B to D consisted largely of unmanaged grassland dominated by fleabane with other ruderal species, bramble scrub, other tree and shrub saplings and some grasses. Meadow vetchling may have been present along the southern edge of the sites prior to the development was continuous deciduous woodland, a priority habitat with a watercourse. In respect to species on each site, para 1.3 of the assessment provides that the areas to be affected by the proposals have been assessed as providing negligible potential for protected species. Mr. Sibbett explained the true position, which is that the open habitat was suitable to support reptiles, breeding birds, invertebrates, hedgehogs, badgers, bat foraging. The woodland was suitable to support those species groups and also protected plant species and bat roosts, in particular the presence of the vicinity of meadow vetchling and bird's foot trefoil, food plants of the wood white butterfly, indicates that appeal sites B, C and D may have been suitable to support this protected and priority species. Impact. In respect of appeal site A, habitat, the table on page 20 of the appraisal provides that the development has resulted in the loss of 0.054 hectares of woodland. Mr. Sibbett measured the amount of woodland lost and found the area to be 0.09 hectares, a significant loss on the borough scale. He referred to local plan policy NE1, where priority habitats are classed as local designations, indicating it has value on a borough scale. Mr. Sibbett also recognised that a section of watercourse has been lost, significant at parish scale, and not recognised by the appellant as harm. In that regard, policy NE2 is breached. In respect to species, pages 17 to 19 provide the development could have resulted in the destruction of protected plant species, habitat for nesting birds, destruction of birds' nests during woodland felling, killing of reptiles, loss of reptile habitat, loss of important invertebrates, loss of bat roosts, loss of foraging and commuting habitat for bats, that it could have resulted in destruction of badger sets, and that the use of lighting could deter bats. Mr. Sibbett added that species present in the woodland would have been lost, and, for example, great crested newts, if breeding in thatched house farm pond, may have been present and lost. Furthermore, the woodland may have been providing shelter, woodland edge, to benefit wood white butterfly, and that benefit has been lost. This is a butterfly of particular importance and significance, and Mr. Sibbett explained as follows. The first page of his Appendix 9 describes its status in orange text, and the box on the right of the page describes its habitat. Figure 3 shows the site is within the wood white conservation project area. His Appendix 4th page states the wood white is present on adjacent land. Appendix 11 discusses the local conservation project, including at page 22, where it recognises thatched house farm as creating habitat for wood white. Figure 02 of that appendix shows thatched house farm habitat for wood white. Page 10 of the same appendix shows wood white will colonise new areas. Appendix 11 is an extract from the selection criteria for sites of nature conservation importance, and page 57 lists wood white as one species for which presence is a criterion for SNCI selection. In respect of B to D, in respect of habitat, the assessment simply states the proposed development is anticipated to result in the loss of hard standing areas and improved grassland. For C and D, it will result in the loss of hard standing. Mr. Sibbett explains the true position in his proofs, which is that the loss of deciduous woodland significant at borough scale and loss of the watercourse significant at parish scale were not recognised. In respect of species, 6.3 of the EIA and 1.3 of the EIA for the respective appeals incorrectly provides for a negligible impact on protected species with no further surveys required, and that the sites had negligible potential to support protected species. As Mr. Sibbett made clear, all the species present in the woodland and open habitat as discussed in paragraph 114 would have been lost, including the wood white. This is of particular importance as the open habitat of appeal sites B to D was suitable for wood white. Conditions and compensation. Mr. Sibbett explained that in relation to Site A, no surveys were carried out for roosting and foraging bats, hedgehogs, birds and invertebrates. The surveys actually carried out for Site A were inadequate. Great crested newt, the relevant pond, was not surveyed. Badgers, camera traps required weren't used. The botanical walkover was not carried out, so species names are not recorded. The significance of this is that the compensation and enhancement strategies are not possible because they have not been properly informed by surveys. It is unclear which species are being compensated for, or the abundance of those species. Mr. Sibbett noted that it was remarkable for the report to assert that there was no impact on reptiles when their habitat had been removed. Mr. Sibbett relied upon the provisions of Circular 06/2005, which notes it's essential that the presence of protected species that may be affected is established before permission is granted, as the inspector at his Appendix 5 held. Although the appellants relied upon the Lawn Lane decision, Mr. Sibbett explained that this was not comparable, as the permission there was not retrospective, and the inspector based her assessment on the evidence submitted, not what had been on site. Mr. Wood suggested compensation for sites A and B, but Mr. Sibbett explained that the provision of a 1 metre wide strip of grassland would be too small and shady to provide suitable compensation habitat for woodwide or for any other species habitat. The appellants have provided no evidence that this rare butterfly, only found in rural areas, can colonise and thrive in domestic curtilages. Furthermore, the proposed condition for a grass strip and hedge planting is not satisfactory compensation for loss of deciduous woodland and watercourse, because it's not the same habitat or same size as the losses. He explained that the proposed condition in Mr. Wood's proof is unachievable for appeal sites A and B. Appeal A contains further work needed, which in itself is uninformed by survey, so the condition can't be implemented in such a way that it can demonstrate that it provides adequate mitigation or compensation. Appeal B contains no mitigation, so it's unclear how the condition could provide mitigation or enhancement. In terms of mitigation, Mr. Woods referred to this as balancing things up, not understanding that policy NE1 required avoidance of mitigation or harm, rather than compensation for what had already been lost. Harm is caused by breach of NE1 and NE2. The watercourse has been removed across the sites and no 5 metre strip left. Given all of the above, Mr. Sibbett's categorisation of that harm as being significant in terms of paragraph 193 of the framework is to be preferred, as is his conclusion that the appeal should be refused on this basis. Mr. Sibbett explained that should the permissions be refused and enforcement action taken to remove the development, as Mr. Woods accepts can be done and has been done in respect of C and D, the habitats will recover through natural regeneration and species will move back in. Dominance of the nearest settled community. Policy C, paragraph 14 of the PPTS, provides that when assessing suitability of sites in rural or semi-rural settings, LPA should ensure that the scale of such sites does not dominate the nearest settled community. In terms of approach, after cross-examination of Mr. Woods and your questions, Inspector, it's common ground that paragraph 14 is to do with scale. It is not to do with services. Paragraph 14 remains part of the PPTS and it must be applied. A hamlet of 30 dwellings could be a settled community, and a settled community is distinct from a settlement. You have the advantage of the decision of Inspector Gilbert, who considered the corner site to the east of the existing sites. She provided the answer as to why pitches to the north of Crocus Lane are of significance to the assessment of whether the scale of such sites dominate the nearest settled community. This is because she flags the issue at her paragraph 20 of a spatial increase in the extent of Lydia Park being the key determinant. In so doing, she's plainly drawing on her earlier conclusion at paragraph 13 that permissions granted south of the track do not create the same spatial dominance because the size, layout and infill position to the south fundamentally differentiates them from the proposal before her. It is this fundamental difference which she draws on later in paragraph 20. Mr. Woods has not appreciated this, and this explains why he had not understood the different effects she seeks to describe in respect of the application before her to the north of the track from those to the south of it. Mr. Woods had also not appreciated that this was the reason why the council permitted development in WA 2025-00451. At PDF page 11 of the officer's report, it is noted that the proposal represents infill development, which will not extend the physical envelope of development to the north or encroach further into open countryside. It notes that the spatial arrangement of the site is the key determinant and that the spatial relationship between the GT sites and nearest settled community, the 20 dwellings on Stovolds Hill, would be largely unchanged by that development. Finally, Mr. Wood's inclusion of the Dunsfold Aerodrome site as part of the nearest settled community is simply flawed. As it has not yet been built, it cannot be part of the nearest settled community. In any event, the site view will have confirmed Inspector Gilbert and the council's view that the nearest settled community is as they describe. It follows that once the approach of Inspector Gilbert and the council is properly understood, that approach as recommended by Mr. Ward is to be preferred to that of Mr. Woods. The location north of the access track is the key spatial determinant of whether the scale of any development will dominate the nearest settled community. Given the evidence you have heard on this inquiry, particularly the effect of crossing the access track and encroaching further into open countryside, these sites would result in domination of the nearest settled community were permission to be granted. A 5-year supply of sites. In the present case, as already explained, National Landscape and Flooding considerations provide a strong reason for refusal under footnote 7, irrespective of whether such a supply exists. These considerations mean that although the provisions of paragraph 11D would be engaged in the absence of a 5-year supply, the lack of such a supply would not operate to trigger the tilted balance discussed in paragraph 11D2. The importance of being able to demonstrate a 5-year supply is provided in paragraph 28 PPTS, which provides the provisions in paragraph 11D of the NPPF apply if a local planning authority cannot demonstrate an up-to-date 5-year supply of deliverable sites. Paragraphs 9 and 10 of the PPTS explain how a 5-year supply can be demonstrated. First, under paragraph 9, LPA should set pitch targets for gypsies and travellers as defined in Annex 1, which address the likely permanent and transit site accommodation needs of travellers in their area. And second, under paragraph 10, LPA should, in producing their local plan, A, identify and update annually a supply of specific deliverable sites sufficient to provide 5 years' worth of sites against their locally set targets. From this, the following is clear. First, in respect of the target, this must be set as a number of pitches which address the likely needs of travellers in that LPA area. There is no requirement for this target to be enshrined in any particular document, but the way this is usually done, and has been done in this case, is to provide a GTAA. ORS have produced more than 180 such documents, many of which have been the subject of successful local plan examinations. And in this case, the one produced for Waverley has a recent base date of end September 2025 and covers the likely needs of all travellers in the Waverley area as now required by the PPTS 2024. This is the lawful target for paragraph 9 and 10 purposes, and there is no other against which such needs can be measured. Second, in respect of the demonstration of a 5-year supply of deliverable sites, LPA should identify and update each year a supply of deliverable sites sufficient to provide 5 years' worth of sites against the locally set target, in this case the target in the GTAA. The identification of such a supply under paragraph A is one of 5 matters, A to E, LPAs will do in producing their local plan, but paragraph A does not provide that such identification need be done in any particular way, save that such a supply must be identified against the locally set target. Pausing here for a moment, should it be suggested by the appellants, not suggested in evidence, the identification of a supply can only be done in a local plan document, this is nonsensical. Paragraph 10A does not require this. Paragraph 28 requires demonstration of a 5-year supply. Paragraph 10A explains that this is done by identifying supply of specific deliverable sites. The opening words of paragraph 10 explain that LPA should address 5 specific matters when producing their local plan. These include matters such as protect local amenity and environment. Plainly, these 5 requirements are identified as matters which will be addressed in producing local plans, but that does not mean that they cannot be addressed in other documents. In respect of A, the identification of a 5-year supply, this is addressed properly through the GTAA and has been put before the Council Chief Executive. Furthermore, and for completeness, Mr Woods does not suggest any other target figure against which to calculate the 5-year supply. He suggests that it may be regarded as a minimum, but suggests no other target to use. Whether there exists a 5-year supply of specific deliverable sites as measured against the locally set target requires the identification of the target and consideration of whether there is sufficient supply to meet that target. So these submissions to address the target first and then the supply. Target. The 2025 GTAA in Figure 2 sets out the current 5-year locally set pitch target in Waverley for 25 to 29 is for 50 pitches. This is the relevant target for paragraphs 9 and 10 of the PPTS, as it the most up-to-date locally set pitch target that has been established in the most recent GTA for Waverley. A comprehensive approach. Whilst the GTA includes the 13 undetermined households from Figure 2 within the target, it should be noted, Inspector, that it did not have to do so, and this has been done to ensure a comprehensive approach. As explained within the methodology section of the GTA at paragraph 3.30 relating to the local plan examination report for Malden, ORS do not usually include undetermined need within the target figure. This is because paragraph 9 of the PPTS defines the target as being required to address the likely need for pitches. The Malden inspector made clear that need from unknowns should be identified through the planning application process. The reason for that was that whilst there remains the possibility that up to 10 further pitches may be needed, that cannot be said to represent identified need. He further explained that such needs have not been established to exist. It follows that undetermined need is not established to be likely in the words of paragraph 9, nor has it been identified in the words of the Malden inspector. But to ensure that the target figure is as inclusive as possible, Waverley have included these within it to raise the 5-year target from 37 to 50. It follows that in demonstrating that a 5-year supply exists, Waverley have demonstrated that both the PPTS need and undetermined need can be met. Bricks and mortar and 3 specific sites. In his rebuttal on need, Mr Woods sets out 2 principal reasons why he suggests the target figure should in fact be higher. 1, bricks and mortar households, and 2, his assertion that 3 sites are inaccurate. The overarching point remains that even if Mr. Woods were correct on these issues, as discussed above, they could not affect the target figure. But in any event, Mr. Woods' concerns with respect to him are not well founded. In terms of bricks and mortar households, he notes that the 2021 census identified a number of households identifying as gypsies and Irish travellers and Roma living in houses, flats and masonettes. Mr. Jarman in his GTAA and the roundtable provided the answer. Firstly, the census records ethnicity and household type, but not any indication of need. The 25 GTA deals with bricks and mortar at Chapter 3. Contacts were sought through a range of sources, including the interviews with people on existing sites and yards, information from stakeholder interviews, and information from housing registers, and information from planning agents known to operate in the area. Interviews are sought with all identified households. To this list, Mr. Jarman added already council officers, friends, family and travellers, and the Surrey County Council Traveller Education Service. Mr. Woods' roundtable was unable to identify any other body to consult, but maintained that the households identified in the census weren't interviewed. This ignores the obvious problem that these people are not identified and so are not contactable. Mr. Jarman said it was not reasonable to expect thousands of letters to be sent by the council asking people whether they were gypsies and travellers, and that is plainly correct. Mr. Woods suggested that Mr. Jarman should have assumed a percentage figure for bricks and mortar need, but did not suggest what this would be. Furthermore, Mr. Jarman referenced the Malden inspector and explained that assuming a percentage on the possibility that further pitches may be needed cannot be said to represent identified need. He further explained that such needs have not been established to exist. The second factor which Mr. Woods relied upon as an indication the GTA need should be higher was his asserted errors on 3 sites, Legend Acres, Old Mill Farm and Twin Oaks. He accepted that wisteria does not affect the figures one way or the other. Mr. Jarman relied on his rebuttal note as showing that Legend Acres' 8 caravans were present on the site at the September 2025 base date, but were not occupied. The occupiers of the site saying an application had been made and they were awaiting its outcome. Mr. Woods said that the caravans were present at the base date, but not that they were occupied. Although the temporary permission at Old Mill Farm has expired, it should now be treated as tolerated, with an original permission granted in 2013 and so would not add need. And the permission for a dwelling house at Twin Oaks is for current residents simply seeking to meet the needs of their family and so would not affect the target. For completeness and for your notes, Inspector, Mr. Jarman addressed 2 specific matters of methodology. In answer to your query on how the GTA addressed potential need from in-migration, Mr. Jarman explained that the GTA household interviews identified need from 7 households who had been displaced from existing family sites in Waverley due to overcrowding, who have a need to move back with their families. The GTA makes it clear that any further as yet unidentified need from in-migration will need to be addressed through robust development management policies. Malden principles apply. And in answer to your query relating to new household formation, as to why the GTA uses different new household formation rates for households that meet the planning definition and for undetermined households, Mr. Jarman explained that this issue is set out in Chapter 7 of his report. And this explains that for households that were interviewed who meet the planning definition, the number of children living on these sites is known. So this local demographic evidence has been used to uplift the national ORS information rate of 1.5% to 1.9%. This is because the national rate is based on 36% of children being aged under 18, and in Waverley this figure is 46%, so the rate has been increased appropriately. Whereas for undetermined households, the number of children living on sites is not known, as interviews were not able to be completed. As such, the ORS national formation rate of 1.5% has been applied in the absence of local demographic evidence. And the GTA makes it clear that any identified need for undetermined households will need to be addressed through robust development management policies. Malden principles apply. Accordingly, even were it possible to do so, there is no basis to go behind the direct evidence gathered during the GTAA, which provides the best evidence of the need present on each of these sites at the time of the GTAA base date. The target is 50. Supply. The Council can demonstrate a 5-year supply as shown in the table below. There is also the issue of the 28 pitches occupied by non-gypsies and travellers, which have been netted off as available supply against need in the GTA before the target has been calculated, which will be addressed under sites with permission for completeness. Current target, 50 pitches. PDA outcome, 58 pitches. Outstanding allocations, 9. New pitches permitted, 6. Current 5-year supply, 73. Surplus 5-year supply, 23. Deliverability is assessed in the PPTS by reference to footnote 4, which provides, to be considered deliverable, sites should be available now, offer a suitable location for development, and be achievable with a realistic prospect that development will be delivered on the site within 5 years. Sites with planning permission should be considered deliverable until permission expires, unless there is clear evidence that schemes will not be implemented within 5 years. It follows that the test for sites with permission differs from those without, and these submissions consider the matter accordingly. Sites with permission. Sites with permission should be considered deliverable until permission expires, unless there is clear evidence schemes will not be implemented within 5 years. It is not asserted that any of the sites with permission have not been implemented. However, it is suggested that the 28 pitches occupied by those who are not gypsies and travellers cannot be relied upon, so I deal with that first. The 28 pitches at Lydia Park with permission for gypsy and traveller pitches, but occupied by those who are not gypsies and travellers, all benefit from planning permission which has been implemented, and therefore the pitches are deliverable by operation of footnote 4. The issue here, Inspector, is that if these pitches were occupied by gypsies and travellers, they could not operate to reduce the pitch target from 78 to 50 because they would already be occupied. The table below demonstrates not just on the best evidence, but beyond any reasonable doubt that these pitches are not occupied by gypsies and travellers. This is because, as is made clear by Mr. Ward and Mr. Jarman, in respect of each of the 28 pitches, either the pitch is vacant or Mr. Jarman's team at ORS have expressly spoken to the occupiers and been told they were not gypsies and travellers. And in respect of many of these pitches, these 28 pitches, evidence is provided showing that they are being rented out on the open market to anyone seeking to rent a mobile home from month to month. I have collated the evidence of appraisal comments and adverts from Appendix 16B and included these as columns beside the relevant permissions. And there you see, Inspector, I've done that, basing it essentially on Mr. Ward's page 24 table, but removing those that aren't relied upon as the 28 capacity. And I've given you the appraisal comments and the advert references from CW 16A and CW 16B. So I won't read that through, but that collates the information into a usable form. And turning over to page 54, Inspector, the new permission. At Ranch Park, 5 new pitches were granted permission in March 2026. The details of this have been provided at ID 22, Inspector, in answer to your request to have details of all permissions granted at Lydia Park. This permission benefits from the operation of footnote 4 and is deemed deliverable with no clear evidence provided that the permission will not be implemented within 5 years. Sites without permission. For sites without permission to be deliverable, they should be available, offer a suitable location, be achievable within a realistic prospect that development will be delivered on the site within 5 years. The key points to note here, Inspector, are that the underlying test for sites without permission is that there should be a realistic prospect that development will be delivered within 5 years. It is fanciful to suggest, in respect of any of the PDA sites, that there is no realistic prospect of development being delivered within 5 years. This is especially the case because the context for PDA sites is provided in paragraph 9.5 of the PDA. The PDA examines the capacity of existing sites to meet their own emerging need. This is the whole basis for the PDA spreadsheet and tables. Given that permission already exists for all but 3 of these sites, the others being tolerated, in the light of the further engagement detailed by Mr. Jarman in his page 3 table, including confirmation with each owner of the sites within his page 3 table that all but the 2 discounted pitches could be delivered within 5 years, alongside the suitability information provided by the Council in relation to the remaining sites, it is plainly realistic these sites will be delivered within the 5-year period. Although Mr. Wood sought to suggest that some of the remaining PDA pitches faced possible issues with surface water flooding or the need for SANG and SAM contributions, these are plainly issues which can and are dealt with at the planning application stage. They do not mean that it is unreal to suggest such additional pitches could be delivered in 5 years. In relation to flood risk, these sites are fundamentally different from the appeal sites because they cater for the need arising from those already on site and don't involve new operational development and caravans in areas at risk of flooding, nor do they make flood risk worse elsewhere. And Mr. Wood's suggestion that PDA sites offend policy DM37 because the pitch side is misplaced because they all benefit from the extended family exception. Each of the sites queried by Mr. Woods is addressed in the rebuttal note, pages 7 to 10. In relation to the unspent allocations, these contribute 9 to the supply as follows. DS15, 7 Burnt Hill, 3 allocated pitches added, DS17 Monkton Farm 5, and DS19 Thornfields 1. When the actual evidence on supply is examined, as it has been at this inquiry, it is plain that the Council can deliver well in excess of a 5-year supply of deliverable sites. The best evidence confirms that the pitches are all available, suitable, and achievable with a realistic prospect of delivery within 5 years. It follows that on the best evidence, there is a 5-year supply surplus of 23 pitches. It also follows that the best evidence is that there are pitches available for the site occupants to move on to within Lydia Park itself. Although Simon Doherty of Pitch B said he had made inquiries, he did not say how extensive or of whom. Furthermore, his suggestion that all the sites at Lydia Park are occupied by gypsies and travellers lacks credibility in the light of the evidence within CW, that should be Inspector 16A, 16B and CW8. Examples of pitches available to the applicants include 0516, now WA 2025 1859, page 5 of CW16B, original planning permission for 5 pitches, a BCN served in respect of excess caravans, planning permission was granted to increase to 9 pitches, now there are 5 statics on site and unoccupied, and 1866 Yellowstone, page 13 of CW16B, planning permission for 9 pitches, originally 31 park homes, but just 2 gypsy and traveller households in occupation. Spatial strategy and intentional unauthorised development. The development plan provides that the needs of gypsies and travellers will be met in accordance with a plan-led approach, employing a spatial strategy which balances the need for such sites with environmental harm. This provides, through a combination of policies, a mechanism by which suitable development which respects the need to balance gypsy and traveller needs and the need to protect other important interests such as countryside, national landscape, ecology and flooding, may come forward outside of built-up areas of settlements. These considerations are particularly important in this case because the evidence demonstrates that development proposals would represent unallocated development in breach of the Council's spatial strategy and deriving no support from its policies. Development proposals would represent the taking of development across Crocus Lane, which currently presents a firm edge to Lydia Park, as recognised by Inspector Gilbert and the Council in the permissions which they have granted. Whether development should be permitted in such a location within the open countryside and causing a series of harmful effects on landscape features and views is a matter for a local plan examination, not a Section 78 inquiry. Such a strategy recognises the fundamental need to ensure development should be plan-led, inherent in the legislation, which established a statutory presumption in favour of the development plan. The presumption is re-emphasised in the Gladman case, in which Lord Justice Sales stated, since an important set of policies in the NPPF is to encourage plan-led decision-making in the interests of coherent and properly targeted sustainable development in a local planning authority's area, significant weight should be given to the general public interest in having plan-led planning decisions, even if particular policies in a development plan might be old. There may still be considerable benefit in directing decision-making according to a coherent set of planned policies, even though they are old, rather than having no coherent plan-led approach at all. And that analysis, Inspector, respects the dicta of Lord Carnworth in the well-known Suffolk coastal case. The fact that the gravamen of this policy framework is breached, with substantial harm being demonstrated to national landscape, valued landscape, ecology, flooding, puts the development squarely at odds with the spatial strategy and the core principle that planning should be generally plan-led. To use the words of Lord Carnworth, the framework does not purport to displace the primacy given by statute and policy to the statutory development plan. It must be considered consistently and so as not to displace or distort the statutory scheme. Intentional and authorised development. Following the evidence, it's common ground that the development represents intentional and authorised development. The only issue is the degree of weight this issue should be afforded. You have the benefit, Inspector, of Mr. Ward's considerable experience in this field and his discussion in the evidence of factors relevant to the scale of IUD. Mr. Ward suggests the weight afforded should be substantial in this case on the basis of the harms discussed above. Mr. Wood suggested that the weight which should be afforded was less than this, but would be greater had the individual applicants themselves carried out all of the works. With respect to him, this analysis is clearly flawed. It is the development which is the focus of the principle discussed in the written ministerial statement, not the individual who carried it out. Were it otherwise, the owner of Site A could ask the owner of Site B to carry out the development to his site, with all of the attendant harmful effects. He could then maintain that the principle did not bite, because he had not personally carried out the development. This only needs to be stated to be seen to be incorrect. It is the development for which permission is sought, and if the development is IUD, then the weight which should be afforded relates to the harm which has been caused, whoever happens to have carried out the development. Accordingly, Mr. Ward's interpretation is to be preferred for development which, for Site A, includes infilling the watercourse, laying of hard standing over most of the site, greater than applied for, necessitating felling of trees, the loss of woodland vegetation, importation of a mobile home and Torah, fencing, gate pillars, entrance gates. For Site B includes filling of the ditch, laying hard standing across most of the site, necessitating felling trees, importation of mobile homes, hard standing, laid in various stages with additional hard standing either side of the access, and additional to the north of Simon Doherty's mobile home. Mr. Doherty described purchasing the site in June 2021, at which time the front was already stoned, so the ditch was filled, but the majority of the site was grass. For sites C and D includes the laying of the access track, filling the ditch, necessitating removal of trees, creation of hard standing of the whole of the rectangle, importation of mobile home and tourers on site, and substantial fencing around both sites. And that should be on site C and D, Inspector, obviously not site A, so that's a typo. It is submitted that these facts represent a clear case of the type of behaviour which the written ministerial statement is trying to prevent. As a result, the best evidence is that substantial weight should be afforded to this consideration. Personal circumstances and child's best interests. Should they be relied upon, Mr. Ward accepts that personal circumstances in the present case should be given substantial weight in the balance. However, the point is that given the context of this case involves citing highly vulnerable development in an area subject to high risk of flooding, the latest flood depth information shows up to 600 millimetres of floodwater across sites C and D in the design flood event and up to 900 millimetres across A and B. The best interest of the child would not be served by living there. Even were that not the case, a further point requires emphasis. As Mr. Ward explains in his written evidence by reference to the Stevens case, and note, Inspector, at paragraph 68 is the final sentence, but at that point, Mr. Justice Holbrook had expressly considered the effect of ZH Tanzania. And he says, but it's not to be assumed in an area of social policy such as planning that Article 8 rights, even of children whose interests must be treated as primary, will often outweigh the importance of having coherent control over town and country planning, important not only in the public interest, but also to protect the rights and freedoms of other individuals. In practice, in my view, such cases are likely to be few. It follows that although personal circumstances weigh in favour of the grant of permission, should personal circumstances be considered, given the particular medical needs of some of the children, the best interests of the child are not served by living there, and this would count heavily against the grant of permission. In any event, given the harms identified, this is not one of the rare cases where such interests would outweigh the importance of having coherent control over town and country planning in the public interest and protecting the rights and freedoms of other individuals. In terms of alternative sites, Mr. Ward's evidence demonstrates that alternative sites exist at Lydia Park. Planning balance and conclusion. Given the balance of the evidence which you have heard, Inspector, in particular that relating to the harm the development proposals would cause to valued landscape, national landscape, intrinsic character of the countryside, views, spatial strategy, highly vulnerable development in an area of high risk of flooding, failure of the sequential test, the exception test, harm to ecology, that caused by dominance of the nearest settled community, and the fact that development represents intentional and authorised development, Mr. Ward's evidence is to be preferred that any balance comes down in favour of dismissing the appeals and refusing permission, either on a temporary or permanent basis. His balance can be summarised as harm to national landscape, great, harm to valued landscape, great, harm to character and appearance of locality, significant, visual harm, significant, ecology, substantial, flood risk, great, dominance, significant, harm to the spatial strategy, substantial, IUD, substantial. Personal circumstances, should they be considered, substantial in terms of personal circumstances, but the best interest of the child would weigh substantially against permission in any balance. Should it be found contrary to conclusions of section 4 above, that a 5-year supply has not been demonstrated, this would engage paragraph 11D, but for the reasons explained, there are two factors, flooding and national landscape, which would engage paragraph 11D1 and provide a strong reason for refusing permission. Should individual harm not be sufficient to merit refusing permission, it is submitted that cumulative harm would be. Accordingly, for the reasons set out above, you are respectfully invited, Inspector, to dismiss the appeals.
Thank you, Mr. Lintott. I think there are just a few points I need to check with you. The first is on page 20, and it's your paragraph 59H. And you make a number of references to ID 23.
Yep.
I just wanted to point out that ID 23, I think, is the draft note.
Yep.
Concerning flood risk, not the agreed note, and
No.
subject to what I'm going to say later on,
I appreciate it.
ID 23 may be a slightly different document.
Yeah, no, I accept that, Inspector. I drafted that on the basis that it would have been agreed. But
Yes.
obviously at this point, we haven't had that confirmation.
That's right. Page 29, paragraph 86. I'm assuming there's a typo here. Should I read for thatched cottage farm, thatched house?
That is a typo. I thought about stopping as I was going through at the time, but didn't. So yeah, you're right.
Yeah, there's not On 2 pages on, page 31, paragraph 96. You say towards the end, the water does not appear able to now reach the watercourse. And I read that as relating to the surrounding fields, but beyond to the east of the
Yeah.
site C and D, I'm not sure that that would be the case.
No.
The ditch is still in place.
Yeah, no, I agree with that qualification. That's right,
Yeah.
Inspector.
Page 46, 141. And it's right at the very end. I don't think when we were when there was reference to how the council had considered the GTAA, I don't think it's the chief executive who is the senior officer. I think it was my recollection is that it was put before the executive board or an executive committee, which would.
So I'm not.
I just
thought
said the executive, so.
The executive, yeah,
okay.
the executive wouldn't normally be the chief executive.
What Mr. Ward said, it was that it was a note for the executive committee.
Yes.
That's exactly, yep. Exactly, sir. And no ratification, just a note. No.
Understanding what's before me.
Yeah, your note is right, Inspector. So that I accept that qualification.
And then just one last point, and it's just the consistency with what's been put in. Page 51 and the table which appears below paragraph 156.
Yep.
And it ends up saying a surplus supply of 23 pictures.
Yep.
Now I can see the maths that have been gone through in that table, but I don't think that's what Mr. Jarman says in his evidence.
Well, he submitted that in respect of your request that he submit something in DS sites. He provided a
Yes.
note laying that out, that calculation last night.
I think that information alters what he's putting in his
so
update.
You're right. So he didn't refer to the
I think he said
LPP2
58.
allocations. Yeah, you know that. So the 58 is the PDA outcomes.
That's right. Yes.
He didn't know about the 6 pitches which were permitted post GTAA. So that's the evidence that came in respect of your earlier question. So that's the 6.
Yes.
And the 9 are the LPP2 allocations, which we discussed in the roundtable. So
And
you're
it's
right.
it's
with
that
those
15 that takes us 58 to 73.
It is indeed. Yeah.
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 Sorry, I thought that was the last point. There's just one final one.
Yep.
Which is page 59, paragraph 175.
Yep.
And this is simply as a result of the site visit today. There are some differences in terms of the caravans that we saw on site.
I see.
From
Okay.
from what's said there.
Well, that was my understanding from Mr. Ward's evidence previously, but I mean,
Yes.
I'm happy you having just seen the site. Obviously.
Just by way of
yeah.
example, in point C, in relation to site C and D,
Yeah.
site D currently has no mobile home. It has 2 tourers
It's 2 tourists.
and a day room,
Yeah.
but no mobile home.
So, Inspector, I'm happy to defer to your better understanding, having just seen the
Yes.
site on that
But-
point. Yeah.
But thank you, Mr. Linsott. It's Mr. Masters up now, but I think we should take a short break before Mr. Masters you begin. And can I just check with you, and I'm looking for your agreement. You gave me an estimate of an hour. Yes. Excellent. Right.
So could I just say that I apologise, but I haven't seen whatever Mr. Jarman sent in last night. And I would like to take instructions on. I was
Mr. Jarman last night? I don't think he did.
Do you mean that the note that I think he means the note that Mr. Jarman sent in relation to, Mr. Bennett sent in from Mr. Jarman on the DS sites that we just described. So that's the note I think that Mr. Cottle's talking about.
It was all sent
Yeah, so it's sent last night.
that can't be relied upon. I've not been here. I've written my whole submissions based on evidence I haven't seen. It just
Yes.
has to be excluded.
Well, no, I don't
asked
think
for it.
that was the case. I think it was simply a note recording what had been discussed at the inquiry, not submitting
Oh,
anything.
wait, if it's just a note recording,
Yeah,
so.
that was my understanding, because that was all what I would
It's-
want at this
it's
stage.
All it does is it records the 6 and the 9 from the
Yeah.
DS sites that we discussed in the.
There were matters that were raised in the inquiry session, and I just wanted a record, because sometimes I'd rather have an agreed record on things that are factual, rather than always rely on my notes, particularly with the air conditioning on. Make sure that I've got the accurate numbers down. That's all that's my understanding, is that is all it is.
I began by apologising, just to say that I hadn't seen it, and I would like to see a copy. What I would like to add is good news is that I've written out my submissions, and they're half the length to Mr. Lintott's. So that I'm hoping that I'll be less than an hour. And I would like a longer break at this juncture, because we did have something from Mr. Quigg on the flooding mapping summary as regards the depths, and I'd like my learned friend to see it, because I think we've got it in a form that you should see. It won't necessarily be agreed, but it doesn't do anything contentious other than just recording what he says the depths are on the mapping system.
Yes,
It's not
the-
giving evidence.
I mean, the same point applies as far as I'm concerned, Mr. Cottle. At this stage, factual information only, no new commentary. What I was going to suggest, if that hadn't been able to be, if it's not able to be agreed today, was simply to give the main parties till the end of this week to sort the documents out. But I mean, it's good news what you say in terms of the length of your closing submissions. What did you have in mind in terms of an adjournment? I was originally going for 10 minutes, but
Well, if you want to finish by 5, yeah, if we're having this note, then it's less concerned to talk to Mr. Lintott, because we're going to have a few days afterwards for the parties to talk about what Mr. Quigg has said anyway. But I just wanted him to see it this afternoon, to complete the picture.
yeah.
So
but-
that, as I understand it, in terms of the note, it comprises a page where the factual information is set down, and then because you asked for the maps upon which it was generated, that the maps have been put in as well for each of the 1 in 100, 1 in 1,000, 1 in 30 events. And so that's all the information is. So it really is just a question of looking at the maps, saying what it is, what's the base
Yes.
date for the information. So I don't anticipate needing to talk very much about it, but I'm happy to do so.
Well,
I think
I'm happy
that's maybe
if
outside
we
the
have the
requirement.
extra benefit of a few days. It's far better that Mr. Quigg has input on the information rather than me putting in something
yes.
that my learned friend hasn't seen, had a chance to digest, so that we have the benefit of a few days to agree.
But
that
what I
note.
am concerned about, Mr. Cottle, is that both you and Mr. Masters should have the opportunity to see the note that's coming from Mr. Jarman, just to have the reassurance that it is what I say, what I understand it to be. I don't want you to be working on uncertainty in that area. Should we say 15 minutes?
Yeah.
It's looks like it's coming up to 5 to 3. We'll resume at 10 past 3, please.
Oh, really? Yeah. So the air comments is over here, so. Yeah.
You can see it's some sort of raised behind that thing. You can, it's true. But there must be something so far, isn't it? How's James getting on with things preserved with trainee? I think this is part of Southeast learning. Yeah, I think part of it. People think so much of the practice. Looks to thing I enjoy most is essentially has on the children. Yeah. Children. Yeah. We're getting gives children. Yeah. In this course of yeah, but how should we? What was that? Well, he's down at Edison's now. Yeah, it's not decent, but what? Just not getting the food. So. But I mean, they did not. Well, this is the top of the hill. So I'm not the first time. 30 years ago, I'm not really the first. But it was, isn't that really? No, 70s. Yeah. It was. Yeah, it was back 70s. Can't be 70s. I would have gone past it. I look up at it. 30. People say it's about 89. Oh yeah, that's the one stuff. Yeah. Maybe. Well. Yeah. Yeah. You said that earlier. Unfortunately, because I was up this morning doing this, very early hours, because I wasn't in this often. Even though. Oh, I was first. Oh, what do you think? I mean, Ghana, they're a good side, they're clearly fit, they're. Only had 2 shots, get 19. Yeah, they're tight. They just, you know, in the old days, where they had 19 shots, they're one breakaway and score on the end. So we threw because we didn't look solid. Yeah. Except for that one incident.
Not the one I'm thinking of, the ones that were far too far out. Did you see that? That would be the same. Anyway, yeah. On Saturday, on the line. Oh my goodness. Where's that? The waitress was there. Oh, yeah, waitress.
this note.
It was, on my mind, it was four, yeah, one thing, four drawings. John said, oh, that's only four pictures. That's fine, I. There will be additional aids.
Is that this Jarman?
Yes, yeah.
All right, thank you. What I'm going to do is, what the, proposing commission.
Yeah.
But what I'm going to do is, that should be named, if you want to put the reps.
Oh, okay, yeah, we would do that anyway. We would, yeah, we wouldn't put them on without, yeah. It's either kept confidential entirely or. We're happy to do that, so we kept that. Yes.
I've got all the list of all the children. And that has to be-
Yes, yes, of course, yeah, no, I'll make a note of it. Yeah, we do check that. Do you meet, Ashley Hurd? Oh, yeah. Yeah. Have you met him before? We've been to Stovolds. Oh, right, yeah.
Time to resume, everybody. It's 3:10. Thank you, Mr. Masters. When you're ready, Mr. Masters, please.
By apologising that this document's full of typos. I was up very early this morning. So I've made changes. So everybody read it carefully because you'll have to note the check the typos as we go on. So I don't, unfortunately, and never have done, do a running closing on the way. But I know you mentioned that you think most barristers do that. I've never done that. One, because I can never, because if an inquiry like this stops halfway through and starts again, you can just rip up and start again. It's all something I do after the evidence. But anyway, so because of the constraints we had, sir, I've done my best, but I do apologise. It is embarrassing when it's full of typos, and I hate it. But anyway, so before I get on to my closings, I do really want to say something about closing submissions generally. Barristers should comment on the law and on the evidence and on the facts. They shouldn't give evidence themselves. And I'm concerned about a lot of the details in my learned friend's closings. Some of them that I think are inaccurate. Some I just don't remember hearing, but that doesn't mean they weren't heard. And so what I'd like you to do, sir, is be careful about reliance on this, and please go back to your own notes of things. And then so we've got my learned friends decided to put things into schedules. On, for instance, his schedule of Mr. Jarman at page 53, which includes the section of appraisal. And I just don't see that anywhere, but I remember in the evidence of Mr. Jarman, it might be that because it relates to mobile homes being empty, that they could be removed, and my learned friend is making some point of his own. But the way that he expressed it was that these were points made by Mr. Jarman, and I simply don't think that's right. So,
Well,
I'll ask
as you suggest, Mr. Masters, I obviously check not only my own notes, but also the evidence that's been put in.
indeed, sir, that's all I ask you to do. I'm not, for one means, accepting anything impropriety from my learned friend. I'm just pointing out my concerns about this and the merely fact that I didn't understand it, but we all make mistakes, including me. Anyway, so going to my own closing submissions, and as you know, I'm not going to, I don't spend an awful long time on regurgitating the evidence you heard, because I have enough confidence in you over the years to understand that actually that's something that you will take your own cognizance of. So my submissions don't do that exercise. They're split into 4 parts. And the first part relates to key submissions from a test to be supplied. And the first heading is need to consider merits of each site separately. These submissions are made for plots A, C, and D, and references are even made to the land being the 3 plots together of the individual pitches separately. In those circumstances, the law is clear. A decision maker must differentiate between each site, and in setting out their conclusions, must clearly demonstrate that approach. So there are 2 famous cases, Reed versus Secretary of State for the Environment and Tandridge in 1993, and I can always pronounce this wrong, Brushweiler and others versus Chelmsford Borough Council in 1994. And these are fundamental principles, sir, that go through the whole matter. And although these cases have been listed together, I know and trust, sir, you will look at each site separately. And the evidence for each site separately. So even though we have 4 planning applications linked together for the purposes of this inquiry, the merits for each must be considered separately. These closing submissions address the main issues in dispute in regard to all 3 sites that I represent, but we ask the inspector to consider each site separately in terms of the issues raised, the merits of the personal circumstances, and to consider carefully how the evidence differentiates between them in respect of those issues. In the 3 cases that I represent, there are some powerful personal circumstances which were acknowledged in the High Court to affect the proportionality of the approach taken in those proceedings. Those matters remain powerful reasons for allowing these appeals. However, in all 3 cases I represent, we do not rely in the first instance upon the personal circumstances of the appellants. Our case principally is that the lack of 5-year supply engages the tilted balance in favour of the developments, so the extensive need and lack of supply alone justify the grant of permission. We say that this site would provide suitable available accommodation to meet some of the unmet need identified in the 2025 GTA, which we say itself underestimates need. It is only if the inspector disagrees with this approach that we fall back on the powerful personal circumstances to justify the grant of consent in any event. So, second heading, the effect of the new MPPF and PPTS on the appeal and the test to be applied, the tilted balance. So in this case, the question we ask the inspector to determine first is whether the tilted balance applies under paragraph 28 of the MPPF. This is submitted must be the starting point for the inspector's deliberations in respect of each site. Whether the tilted balance applies depends on whether the council can demonstrate that they have a 5-year supply. Paragraph 28 of the PPTS states as follows: if a local planning authority cannot demonstrate an up-to-date 5-year supply of deliverable sites, provision in paragraph 11D of the National Planning Framework apply. The tilted balance, local planning authorities should conclude how they could overcome planning objections to particular proposals using planning conditions or planning obligations. The council concede that their plan is not up to date, that they have a demonstrable unmet need for new sites. In the light of the recent GTA, they could not really dispute that fact. Sorry, it says rely, but I think that was a...
Yes.
Yeah, thank you, sir. But we also claim through what is called the pitch delivery assessment, the PDA, that they are able to demonstrate they have a 5-year supply of gypsy and traveller sites to meet the assessed need. This is the issue the inspector will need to look at and determine first. Since it is the council who assert that they have a 5-year supply and the tilted balance does not apply, the burden must rest on them to prove that fact, and particularly to prove that PDA discharges their burden. If the inspector finds the council at the present time cannot demonstrate a 5-year supply, then the starting point for this inquiry must be the tilted balance, and other issues must be viewed in the context of that tilted balance and the test to be applied under 11D. We will come back to this issue below, but first, therefore, we need to look at whether the council can demonstrate they have a 5-year supply and whether the council have discharged that burden in that respect in this case. And so my third issue is, does the council have a 5-year supply? Need first, because I split it up into need and supply. So we say that the 2025 figure of need of 128 pitches represents the minimum figure of need. I will not repeat the detailed criticism of the calculations of the GTA as set out in the evidence of Mr. Woods, but ask the inspector to have cognizance of that evidence and criticisms which we say were not substantially rebutted in the evidence of Mr. Jarman. We invite the inspector to find the need is likely to be much higher than set out in the GTA. We also do not accept the deduction of 28 pitches, allegedly representing those pitches not in occupation by gypsy and travellers on Lydia Park, represents supply, or can safely be assumed to be a correct deduction on the evidence presented by Mr. Jarman. We have great concerns as to the evidence upon which this deduction has been made. It is clear that those resident on site were not interviewed by asking them whether they were gypsies, particularly when the definition is now wider and covers those who would not necessarily self-identify as gypsies, but who still come within the definition. It is not sufficient to simply rely on the fact that someone doesn't self-identify as a gypsy to rule them out of coming within the definition. Care has not been taken to probe further. Simply put, as soon as someone has said that they were not gypsies or travellers, they have been ruled out and no further questions asked. That's what Mr. Jarman said. The criticism is that the GTA has not. The criticisms of the GTA is that they have not re-looked at its questions in the context of a new definition is a valid one. I'll just repeat that again, sir, because this is a criticism made by Mr. Woods in his rebuttal. The criticism of the GTA has not re-looked at its questions in the context of a new definition is a valid one. Moreover, ORS seem to have taken a simplistic approach to site rental. It seems that all of those renting sites are ruled out as not being travellers merely because of that fact, whereas there is nothing in the evidence that proves that renting sites breaches any terms of the relevant planning permissions involved. There is nothing intrinsically wrong in those who meet the definition renting a lawful pitch. That by itself does not prove that persons renting do not meet the definition and are not gypsies and travellers. Further, in terms of supply, there is no guarantee that even if these sites were occupied by those who do not meet the definition, they could realistically be made available to count towards supply. There is no direct mechanism by which, merely because they are not so occupied by those who meet the definition, that they could be made available to meet the need of those who meet the definition, such as compulsory purchase, which is not proposed. So there is no mechanism in the PDA as to how the sites could be made available and delivered to meet the need. And you remember, sir, that delivery is the test under paragraph 28. They can demonstrate a supply of deliverable sites. And there is no mechanism here for making those sites deliverable. So there is no mechanism in the PDA as to how the sites can be made available and delivered to meet the need. In the absence of any such mechanism, the deduction of these 28 pitches from the assessed need is an operation of smoke and mirrors. The reality is that the need will not be reduced because these sites will not be available, because they are occupied. I'll just repeat that, sir. what Mr. Jarman is doing is saying, well, they're occupied by non-gypsies and therefore they can be delivered to gypsies. There's no mechanism for that. But more importantly, sir, there's no explanation how you're going to get the people who occupy them out. And how that can be done within the time period he suggests. Because we can all see the sort of court cases that are going to arise and the things that they're going to say. And so he's asking you, sir, to make judgments that are not your call to make, because those have been made in any proceedings that then occur. Further, even if Mr. Jarman is right that these sites are occupied by those who do not meet the definition, despite what is asserted by Mr. Jarman, there is no investigation or evidence as to the mechanism to bring them back into use to meet need. No evidence as to what the breach of planning is. No evidence as to how long the alleged breaches have occurred. No consideration as to whether the breaches are now immune from enforcement. No consideration as to whether the original occupiers who did meet the definition would simply just return, or what the owners of the pitches would do. The presumption that suddenly they would be available to meet the assessed need has no merit and cannot be justified. To allow a reduction in need in the way calculated by ORF. Furthermore, the assumption, so I've written this in, that just because a caravan is not occupied, it is not being used by a gypsy and traveller who meets the definition, is nonsense. The occupants may just be simply away, sir, travelling. Merely because they turn up and it's not occupied doesn't prove anything. And there's been no additional evidence, sir, by which you could categorically come to the view that non-occupation means that they're not being used. So that column that I took to you to, sir, in his case, that assumes that what you do is you remove those caravans and then create bigger pitches. Well, it's fanciful, sir. I mean, where's the mechanism to do that? How do you do that? Who's going to do that? Is ORS going to do that? Is the council going to do that? Where are the powers to do that? Moreover, if those 28 pitches are not occupied by those who meet the definition, they represent a loss of 28 pitches to supply, not an addition. And that's the key point, sir. Actually, turn it on its head. What it proves is that there's a loss of supply, not an addition. The pitches cannot be safely counted towards supply, ignoring what happens to the current occupants. The council have no power to evict them, and their current occupation cannot be ignored. The PDA does not address this issue, and neither did Mr. Jarman. If they claim gypsy and traveller status, any eviction will just add to need. So even taking the minimum figure of 128 clearly represents a demonstrable unmet need. It is clear that once the council assessed this magnitude of need, they had a problem, since the assessed need far exceeded the allocation set out in the current plan, and there is no proposed new site allocation DPD. Further, since the council will cease to exist in 2027, there is no prospect of any new local plan coming forward to address need. So there is no new local plan on the horizon, no new allocations being considered, nothing up for consultation, no current planning applications in progress relating to these sites, and indeed little time for anything to occur before the council ceases to exist. This is the DPA may represent the council's swan song, sir, but it's going nowhere and doesn't do anything. Supply and problems with the PDA. The PDA cannot replace or bypass the regular process of local plan provision and allocations. It is not even certain whose document the PDA is. It has not been ratified by the council, is not a council document, There is no evidence of council participation in its creation. There has been no consultation with anyone. All that can be said is that it is an ORS document. ORS is a separate entity with no responsibility for housing. Therefore, the PDA and its status is, to say the least, irregular. It has no policy status, conceded by Mr. Ward, no status in any planning policy hierarchy, conceded by Ms. Ward. At least in Townbridge Borough, the PDA was ratified by the council, not here. We say that very little weight can be given to this document. If there was an emerging local plan at an early stage, and having been through any, if this was an emerging local plan at an early stage, and having not been through any consultation, it would be given little weight. We submit this document cannot be given more weight than that example. Despite its severe limitations in this case, the council rely on the PDA as evidence of meeting the 5-year supply. However, in reality, in terms of supply and the PDA, the situation is simply there is no supply, no policy to meet the level of need, no allocations to meet the level of need, and no realistic prospects, sufficient sites coming forward in the next 5 years to address the shortfall. The inspector has detailed evidence of the problems with the PDA and the difficulties with it, and again is asked to have cognizance of that evidence when looking at this issue. I do not intend to revisit the evidence that the inspector has heard from all sides. For simplicity, I've set out the difficulties with PDA in the following bullet points. The PDA is not a policy approved by the council. The PDA is not an allocation and will never become an allocation since the council itself will cease to exist. The PDA is an irregular document and sought to bypass the local plan process, but has not been the subject of any consultation process, nor it has been ratified by the full council. The PDA is not a pitch delivery policy and is aspirational and does not guarantee delivery of pitches. So the PDA, as Mr. Ward said, is not a policy. Therefore, it cannot be a pitch delivery policy. Therefore, what is it? It is not a document that can carry any weight. The way Mr. Ward describes PDA is merely as a document for the information of the council executive. That's the way he put it, sir. It has no valid status in terms of policy or individually in terms of planning permissions. The PDA is not a planning permission, nor is it as a substitute for planning permission, nor does it bypass the planning process or make the grant of any planning permission more likely. In that respect, there is currently no planning applications pending in respect of any of the additional sites sought on the current sites identified by the PDA. Just pause there, sir. Bearing in mind, Mr. Ward said, these sites are up and ready. I mean, that, sir, is just absurd. How can they be up and ready when they need planning permission for these additional pitches? And when there are no planning permissions available, and the pitch delivery assessment doesn't help. It doesn't guarantee planning permission. And we've heard nothing from the owners about willingness to put in any planning applications. So I'm going to read that bullet point again. In that respect, there is currently no planning permission pending in respect of any of the additional pitches sought on the current sites identified in the PDA. It is, as a matter of law, wrong to assert that planning permission exists. They may exist for the sites and for the numbers conditioned, but not for the additional pitches or the additional land to be developed in respect to many of the sites identified. Because the other point, sir, as Mr. Wood pointed out to you, a lot of these aspirational pitches require additional land for which there is no planning permission of any sort. Perhaps the council are going to intentionally unauthorised develop these sites. And that's their plan. I don't know. Further, there is no guarantee, even if planning permission came forward in respect of each site identified, that planning permission will be granted or implemented. The lack of consultation and likely resistance from residents has not been addressed. There is no mechanism to guarantee delivery within 5 years. Reliance, it seems, on what action the private landowners, is on what action the private landowners may take, for which there is no direct evidence. Indeed, not one letter from a landowner who has obtained in support of the PDA. Not one letter saying, yes, we want to put in a planning application and increase this site. Unless, of course, ORS are going to be putting in all the planning applications. So, but then if that were the case, Mr. Jarman would have told you. And you've not heard any evidence the council are planning to put in planning applications or doing compulsory purchase. So where is this document going? What is it achieving? What can it achieve? No compulsory purchase are proposed. No funding has been shown to be available or has been allocated. And since the council will cease to exist, none is likely. But it is unlikely that any funding will come forward or CPO process initiated. Then even if the site obtained planning permission, there is no guarantee that they would be implemented. And even if implemented, they would not go towards meeting the general need, but only the individual needs of those on site. They would not be available to meet general need. Well, Mr. Jarman confirmed that. As Mr. Woods has pointed out, the example of a number of sites would be contrary to policy DM 37. Mr. Jarman says that the sites would be far from this, would be for the same household, and therefore they would comply. But this remains to be seen. There could be no certainty at this stage that would be the case. Then even if those sites became available to add to supply, they would need to be subject to a personal permission, so the benefit of the benefit of those families only. So if they're an expansion on the basis of existing sites, but we're going to share day rooms and stuff, they couldn't then be used general need because they would not comply with policy DM 37. So the whole thing's just not been thought through. Further, the elephant in the room, the PDA proposal contradicts the council's case. There are major contradictions in the council promoting development of a number of sites on Lydia Park in circumstances where in this appeal they have raised objections to further development of Lydia Park, namely 1, over intensification, and 2, over problems with surface water drainage on the access to Stovolds Hill. Both of these concerns was applied to an extended Lydia Park pitches. It seems that council have ditched these concerns in regard to the promotion of further expansion of Lydia Park, and cannot have it both ways. The conclusion, the PDA is not an allocation policy and cannot deliver on sites to meet need, and the inspector should consider that there is not sufficient available or deliverable sites under footnote 4 of the PPTS. Sorry about the little s, to meet the assessed need, and that therefore there is no 5-year supply. The council will cease to exist in 2027, and the new combined authority will be years away from having an emerging policy to properly address the need and allocate sites in the expanded area. Therefore, the tilted balance applies. The effect of the tilted balance, my little point 4. Where the tilted balance applies, the burden shifts to the council to show why permission should not be granted. It's admitted that it is a burden that they have not discharged in this case. Paragraph 11D of the MPPS states as follows: where there is no relevant development plan policies or policies which are most important for determining the application are out of date, granting permission unless the application of the policies in the framework that protect areas of assets of particular importance provides a strong reason for refusing the development. I should have said little Roman numeral 1, so because it's important. Or 2, little Roman, through any adverse impacts of doing so would significantly and demonstrably outweigh the benefits when assessed against the policies in this framework, taken as a whole, having regard to key policies for directing development to sustainable locations, making effective use of land, securing well-designed places and providing affordable homes individually or in combination. So the clear burden on plan is on the planning authority. So in terms of the tilted balance, the MPPF places a clear burden on the council to demonstrate that there is either a strong reason, that's little Roman or numeral 1, for refusing development, where little 1 applies, or that an adverse impact significantly and demonstrably outweigh the benefits where little Roman numeral 2 applies. In this case, the question as to which test applies depends on the inspector's finding on whether footnote 7, surface water flooding, applies to any of these pitches. Other arguments about footnote 7 do not apply. This is not a case where the site is in the national landscape. We know that, sir. Footnote 7 only applies to national landscape, doesn't apply to AGLV, and it doesn't apply to the setting of the national landscape. So I'll read that again. Other arguments about footnote 7 do not apply. This is not a case where it is in the national landscape. It is not and will never be. Mr. Dudley's argument that it's in the setting does not engage footnote 7. This is again not a case where endangered species are present. It's the other aspect of footnote 7. The whitewood butterfly is not in that category in any event, and there is agreed evidence that no protected species have been found on any of the sites in this appeal, and there is no evidence of the pitches being home to protected species, and again footnote 7 is not engaged in that respect. So footnote 7 is only engaged to the issue relating to flooding, and only if you find that's a strong reason for refusal. And I say, sir, since that can be dealt with by condition, it cannot be a strong reason for refusal. The matters may be material to the inspector's balance, but we say on the evidence, footnote 7 does not apply to them. The extent that footnote 7 applies to surface water drainage depends on the inspector's finding as to whether the harm suggested provides a strong reason to refuse the development proposed. If that harm can be properly addressed by condition, there would not be no such strong reason, and the test 11D2 would be met and the tilted balance would apply. Can the harm be addressed by condition? The government has placed a new requirement on local authorities not to dismiss applications where conditions may overcome planning objections. The government has now mandated that councils can no longer sit back, as indeed Mr. Smythe, Mr. Dudley were doing initially before this amendment came into effect, and say that they need the details in advance where it can be demonstrated that it's likely the condition can overcome objections. That's what they were doing first time before that amendment came into place. In this case, refusing to consider that some matters can be dealt by conditions has been the basis of several disputes, whereas it is now clear that the direction of travel of the government is that permission should not be refused where the imposition of the conditions will safeguard the council's concerns. This is particularly so in regard to the objections on surface water drainage and protected species enhancement, all of which are matters to which conditions are usually applied, and where the council remain in full control of the narrative and whether to agree the schemes submitted. So if we've got adequate safeguards, sir, the inspector has heard the evidence, and I will not repeat those matters in this section. Not from me, sir, is long 28 pages of evidence. It is admitted that both of the current concerns can be met by imposing conditions agreed during the inquiry, and that neither should justify refusal due to lack of details. To conclude on this section, we say that the council have no 5-year supply, the tilted balance applies, and there will be no flood risk if the ditches are reinstated and where necessary land levels lowered, and that the issue can be conditioned. Indeed, it will be amount to a planning gain. To repeat that, sir, we know it will amount to be a planning game because there's no other way the reinstatement of those conditions can occur unless in the form of a condition, particularly in relation to Appeal A and B. The test then under the tilted balance is whether any adverse impacts of granting permission for each site, when looked separately, would significantly and demonstrably outweigh the benefits. When assessed against the policies and framework taken as a whole, we will return to the detail in respect of surface water issues and protected species and the tests below. We say that the harms identified, so rather than addressed, here, so you should change addressed to identified. Here, do not significantly and demonstrably outweigh the benefits of granting permission for the pitches. So part 2, other tests to be applied as a matter of law. So I've looked at what I suggest is your main approach, sir, but I've also looked at presumption in favour of plan. It is our case that we comply with the main local plan policy AHN4. AHN4 is a criteria-based policy. Mr. Ward agreed in cross-examination the only criteria in dispute whether due to the surface water there was a safe access to the strategic road network. It's difficult to see, sir, how we can maintain that in view of the council's promotion of all the other sites, expansion of all the other sites on Lydia Park, going for exactly the same access. and whether the site has an unacceptable impact on physical and visual character. Again, sir, it's difficult to see how Mr. Ward can maintain that in view of the wholesale expansion of Lydia Park and the impact that that's going to have on physical and visual character under AHN4. I mean, the contradictions are stark. The elephant in the room, sir, is sitting right in front of us all. The inspector has heard the evidence and dispute in respect of these matters. The service water access matters comes back to whether a condition will meet any harm found, and in respect of any impact, we say the inspector should find that the impact is not unacceptable. Indeed, it is difficult to see how the council can maintain the landscape farm in the context of the PDA proposals for expansion on other sites in Lydia Park, which are in fact at a higher point in the same countryside location. The council's arguments that the acceptability of the PDA contradict their own arguments as to the countryside harm and conflict with policy AHN4. Section 38(6) of the Planning Compulsory Purchase Act 2003 requires planning permissions must be determined in accordance with the development plan unless material considerations indicate otherwise. Therefore, if the inspector finds we comply with policy ANH4, and so I can't see how we can, in view of all the contradictions of the council, he should apply the presumption and allow permission on that basis. Human rights tests. Sometimes these are forgotten, sir, but they're actually sometimes the most important. However, in respect of the families who wish to reside on site, the inspector has heard extensive unchallenged evidence of their lack of lawful and settled base for them to stay. Clearly, their Article 8 rights are engaged, and the three tests set out in Chapman UK must apply and be applied when adding to the planning balance their personal needs for accommodation and the best interests of the children. It is important, therefore, to remind the inspector how the courts say that an inspector should approach an Article 8 human rights assessment in a Greenbelt case. I know this isn't one, but this is the best place authority to go to. In the case of AZ versus Secretary of State and South Gloucestershire, a gypsy case, Mr. Justice, that should be Mrs. Justice Thornton, sir, by the way. Oh, forget to change that. Set the test out at paragraph 59 and 60 in her judgment when she stated as follows: an Article 8 proportionality assessment is not the same as a consideration of whether the personal circumstances of the applicant amount to very special circumstances. A proportionality assessment must consider a wider range of circumstances. The decision must balance all relevant circumstances in the round. And the onus is placed on the decision maker taking reasonable steps to identify the circumstances that should be considered. By way of a comparison, consideration of very special circumstances in a Greenbelt context is more confined in scope and may be considered piecemeal in a less structured decision-making process. Moreover, the onus of demonstrating the existence of the relevant very special circumstances, such as there is no other site available, is placed on the applicant. In practice, it will be necessary to undertake an Article 8 proportionality assessment in cases involving Greenbelt development decisions where a person's Article 8 rights are engaged. In such a case, a finding that circumstances are such that the proposed refusal decision is disproportionate will almost inevitably be one that amounts to finding that there is very special circumstances. Also, this isn't just very special circumstances case, but it is a case of proportionality. We say it would be totally disproportionate in this case, particularly bearing in mind the council's own failures. Particularly bearing in mind the council's own failures, sir, and the fact that they've got gall, I'm afraid, to promote the PDA, which actually dishes their own concerns in terms of overcrowding, overdominance, and countryside harm. So what's really interesting is that proportionality has not raised itself significantly in the submissions made by my learned friend. We say that properly applying those tests in this case, the inspector will inevitably come to the conclusion it would not be proportionate to refuse planning permission, and in that context, permission should be granted. So cut and pasted from very special circumstances, so that's why I've changed. But there is simply no way that it would be proportionate to evict these families in the absence of suitable alternative accommodation. The following is some additional factors that need to be taken into account when looking at proportionality, and factors like the Council's contribution to the problems, failure of policy, and failure of solutions. Proportionality and suitable alternative accommodation. The Council concede that at present they have no suitable available alternative sites for this family. The PDA sites, if they come forward, so they're not available now, so they can't go to any of those sites tomorrow. Indeed, they can't go there at all because they're not going to be for them. Will not be for the general need. The 28 pitches at Lydia Park, said to be occupied by non-gypsies, are not vacant, and there is no mechanism for them to become available to meet the assessed need. Forcing the families to remain on the road is not safe, and is submitted as a very unattractive argument of the Council in general and in terms of proportionality. The highway dangers that these particular families will be exposed to on a daily basis whilst parking on the road are not to be underestimated, and in reality would be much greater than any dangers associated with service water on the access to the site. The suggestion that the best interests of the children are best served by eviction by Mr. Lintoff is frankly certain nonsense. They will be in far greater danger on the road than left on the site. Part 3, as, by the way, was endorsed by the High Court. Part 3, specific matters and dispute relevant to the balance to be made. So these are really notes of these specific matters, so I haven't gone in detail into the evidence because you know it and you're going to be the one deciding it. The purpose of this section is to look a little closer at the specific issues raised in the context of a tilted balance, 11D. These sites are not in the green belt, not in the national landscape, have no material protection, and will not, since they are excluded by the review of the Surrey Hills national landscape referred to in the local plan policy RE3. The site is subject to the local designation of the AGLV. But, sir, it has no local designation as a valued landscape. That's just Mr. Duncan, no, Mr. what's name's, sorry, Dudley. That's just Mr. Dudley's assertion, for which there is no evidence. But this designation is now redundant, and the council are now proposing themselves, and the council are now proposing themselves in the PDA the expansion of sites on Stovolds Hill. Our case is that we comply with ANH4. There is no unacceptable impact on the countryside. One of the main objections to the council is that the site conflicts with policy RE3, but a close reading of RE3 notes that it will only be retained for its sake until the review of the Surrey Hills national landscape has been completed. This has now occurred, and RE3 must now attach little weight since the purpose now falls away, since the review has not added the site to the national landscape. Para 232 of the MPPF applies. In any event, the harm is a matter of judgment for the inspector. He has heard the competing evidence from the witnesses and will make his own conclusions. However, he is reminded that Mr. Dudley gave evidence before the PDA came into existence, and there was no opportunity to cross-examine him on the contradictions posed by that policy. Bearing in mind that any new gypsy site in the borough will be in the countryside, and now we know that the Stovolds Hill area is actively being promoted in the PDA, it is difficult to see how this could be a strong reason for refusal or outweigh the benefits of granting permission. Service water drainage. The appellant does not dispute the published service water mapping parts of Stovolds Hill frontage and access corridor as being affected by service water flood risks. This is common ground. The main planning question is whether the service water risk exists. It does. The question is whether it can be managed by suitable levels, drainage, reprofiling, storage and maintenance, so that occupiers remain safe and flood risk is not increased elsewhere. The Environment Agency flood map planning, FMF2, service water depth bands relied upon by the council on national scale mapped depth bands. They show the existing terrain, unmanaged, mapped condition. They do not account for raised pitch levels. or filled in drainage routes, which are clearly on the evidence as a reason for the service water risk. Sorry, I should read that. They do not account for, so I'll say this again, sorry, can I just correct this? For the restoration of the pitch levels or filled in drainage routes, which can clearly on the evidence of a reason for the service water flood risk. The FNB track databases are simply for use in development planning. They should not be treated as a surveyed site-specific flood levels, sir. That's a point that's important. They identify the service water issue and help inform the need for a site-specific response. Flood Map 4 was one of the mapping sources available around the time of the original flood risk assessment. Since then, the EAFPI service map database has been updated and now provides the current national service water mapping basis for development planning. It is not necessary to resolve every detail of either the national database or flood map 4 source data to determine the appeal. The important point is that all of the mapping identifies the same broad issue, namely a service water route affecting parts of the frontage and access corridor that has been filled in. For the remaining appeal sites, the appropriate planning response is a condition requiring the modelling of plot-specific levels and service water drainage, and thereafter remedial measures before further stationing, occupation or continuation of residential use as appropriate. That would serve to secure the detailed design response for each plot while recognising that mapped service water is a matter requiring mitigation, not an automatic reason for refusal. This approach is consistent with planning practice paragraph 009 ID, and I won't read it, so you'll read it yourself. Conditions requiring works on land which is not controlled by the applicant.
There's no need to read the
No,
quotation.
sir, I won't, sir. You know what it is. But this guidance is relevant here. The land required to deliver service water mitigation is within the Stovolds Hill landscaping related to appeal sites, and there is the riparian right to reinstate the ditches. I'll just repeat that, sir. So there's no issue with the Grampian because there's a riparian right here. But more importantly, sir, as Mr. Ward said, the county council, soon to be the new council, will have the right to enforce any restoration. And so it can't be suggested that there would be a problem with any condition in that respect. Therefore, there is therefore a clear prospect of a required mitigation being delivered. A negatively worded condition would be a fortunate way of ensuring that the required drainage and levels are secured before further stationing, occupation or continuation of resident use, rather than treating national map service risk as an absolute bar to development. Mr. Smythe's case relies on the current 2025 EA flood map. That mapping for the first time identified the service water issue prior to the ditches being filled in. The evidence disclosed that there was no problem with service water drainage as addressed in the two SFA reports filed with each application, and the mapping relied upon in respect to the FRAs. Mr. Smythe makes much of this to argue that permission should not be granted due to the uncertainty that exists because there is no modelling of the effect of filling in the ditches or raising the level, and he refuses to countenance this can be addressed by condition, including the reinstatement of the ditches and the lowering of the land where required. Refuses to countenance that, sir, because if he did countenance that, then the council would have to concede it could be addressed by condition. His second point is that the sequential exceptions test has not been done in accordance with the planning policy guidance. Though the September 2025 amendments to that guidance support the appellant's case that we passed the test. So I'm not going to, I haven't set out all the amendments in this document because I know you'll go to them, and you can see there was a sea change in approach in how to apply the sequential test. And quite clearly, I invite you to accept Mr. Wood's evidence on this, that we clearly passed that test. We say that it is clear that we passed the sequential test for reasons given in evidence. by Mr Woods, and based on the current version of planning practice guidance, and there are no suitable available alternative sites in the borough to meet this type of development. The only sites that the council can point to themselves are already existing sites on Stovolds Hill. It is a moot point as to whether the exceptions test applies. Neither the PTTS or the MPPF or other policies specifically addresses this requirement when considering surface water drainage. You'll see that yourself. But in any event, the evidence shows we pass this test as well. Any harm can be addressed by the suggested condition, and if the condition cannot be discharged, the planning permission will fail. This is sufficient safeguard. So the exceptions test requires a finding that there will be no harm caused to those on the site or to anywhere else. If a condition discharges that harm because the drainage ditches are restored and you're satisfied that that can be achieved, but more importantly, the condition will have to be discharged by the council, so they will have to be satisfied, then there will be no harm arising that would incur failure of the exceptions test. Factually, sites C and D are not in the areas of concern for surface water flooding, and there is no dispute the occupants will be safe on the sites themselves. The only issue in respect of surface water is in respect of the access route from the site to the junction with the road. In regard to site A, the 2025 EA mapping relied upon by Ms Smythe shows the entire site to be affected by surface water. This is in contrast to the mapping in the FRA based on the UK mapping. Mr Smythe is unable to give any evidence of depth or velocity of the surface water. So the outrageous suggestion that the evidence shows 2 foot, that isn't the case. That's an extrapolation that Mr Smythe takes from the mapping he relied upon. But the footnote to that mapping says don't look at it for individual sites. Get your own, do your own exercise. And that's exactly what would be done in the modelling that would come with the conditions, sir. So there'd be certainty where there's none now. Mr Smythe is unable to give any evidence of depth or velocity of the surface water problem, but the site is on a hill and the water flows downhill. At least, sir, that's what I understand to be the case. So close. So once that fact is taken into account, the answer is there is no danger to the occupants, bearing in mind the mobile is elevated. Mr Smythe raises concerns about surface water on the access to the land, but again there is no evidence that this is a problem that cannot be addressed by the reinstatement of the ditches to allow the surface runoff to drain away, not on the road but in the ditch. Mr Quigg has addressed how any issue of surface water can be addressed by an appropriate condition. Dealing with this concern by condition is generally standard, and there is nothing unusual in this approach. The debate has centred on the fact that the council demand the details now, rather than addressing the details in the scheme proposed by the condition. This is unreasonable, and we rely on paragraph 28 of the new PPTS as being the correct approach should be taken. The burden is on the council to demonstrate why this would not be the correct approach. Lastly, concerns about main access to Lydia Road being affected by surface water are completely contradicted by the council's case in respect of the expansion of those sites for the PDA. The council, again, cannot have it both ways. Protected species. The inspector has heard the evidence, and again, I have no intention of repeating it. There is no evidence of any of the appeal sites are home to any protected species or that any protected species have been affected. There is much opportunity for enhancement, and again, this can be dealt with by condition. The landscaping scheme can include significant elements of biodiversity enhancement, including hedges and other vegetation, as set out by Mr Woods. So I'll stop to say that reinstatement of the ditches will indeed by itself be a planning gain in terms, I would imagine, of foraging routes for the newts. Particularly bearing in mind that some parts of the year they will be wet. Since this again can clearly be achieved by an appropriate condition, it is difficult to understand why this could not have been agreed in the first place. Over dominance. It is difficult to see how the objection can now be sustained in terms of the expansion proposals now relied upon by the council at Stovolds Hill in respect to the PDA. That, back to the elephant in the room, sir, that position completely contradicts the council's position of over-dominance, and again, they cannot have it both ways. Further, in any event, there is a tension between paragraph 14 of the PPTS and the duty under section 149 of the Equality Act, the public sector equality duty, and article 14 of the European Convention of Human Rights. As read, policy 14 does not operate equally, and there is no equivalent national provision operating in reverse. The policy could, if wrongly construed, operate unequally to the disadvantage of the traveller community. This can be illustrated by the Dunsfold Planning Commission, whereby 18,000, it may be more so because I looked at it again, I saw another figure of 25,000. 225,000 houses obtained planning permission on the airfield just up the road from the site, and no question was asked whether the scale of the development of Dunsfold would dominate the Lydia Park gypsy community. And it's a stark example of how this policy is being operated in only one direction and to the disadvantage unequally to the travelling community. It is submitted that care must exist on how policy 14 is interpreted and must be interpreted consistently with the PSD. Mere numbers and scale it is submitted should not be enough to prohibit development, and there must be something more. The defining of what amounts to a settled community must be looked at carefully. Otherwise, you could have a situation where a very small outlying house or houses would stop the development of a much needed provision in an area suitable for that type of development. Previous policies on over-concentration referred to other elements of harm, namely the strain of resources, such as for local schooling or medical resources. Criticism is made of the decision of Inspector Gilbert. He did not address the conflict between the policy and the public sector equality duty, or that it could operate unequally, nor did he attempt to address the issue of settled community and whether the few dwellings here would come within that term. We do not accept that he was correct to categorise a group of isolated dwellings as a settled community. We say they do not represent a settled Stovolds Hill community. If anything, the settled community in Stovolds Hill is both the houses and the gypsy and traveller sites together, as illustrated by the parish council's documentation. Many of the gypsy and traveller sites here have been in existence for over 30 years. To separate out dwellings from gypsy neighbours sends the wrong message about inclusion and should not form the basis of refusal. Baseline in terms of the biodiversity. Clear evidence in respect to sites A, E and D are that the hard standings were present when each appellant obtained the land and sought planning permission. The pitches were sold with hard standing and roads in place. This, I remind you, sir, is accepted by the council and no appellant's evidence on this was challenged. All gave evidence, sir, and none were challenged on that. The baseline has to be the date when the planning permission was sought. It is not the date when the land was purchased. It is either here. So if this was an enforcement case, sir, you'd ask yourself a question about what development occurred by the individuals being enforced against. You wouldn't enforce it against development that occurred before then, particularly if by that time that enforcement had become that development had become immune. And remember, sir, it goes to it doesn't go to directly, in my estimation, to intentional unauthorised development, because if you haven't done the unauthorised development, how can there be intention? But it goes more to the question of baseline in terms of how biodiversity should have been appraised. In either case here, the hard standing was already in place. Hence, The reason that all the biodiversity reports referred to them as part of their study as the baseline, the council cannot revert to a time when the site was a green field and indifferent ownership made it make their case better. The unchallenged evidence is, in this case, is clear. The hard standings were laid separate to the subsequent residential use of the land as a caravan site, as caravan sites. Part 4, list of material considerations. Balance against harms found in addition. So I can move pretty quickly over this section. All I'm doing is listing of the material considerations have been referred to. So need, I'm not going to repeat that. No suitable sites, not going to repeat that. So you can read that at your leisure. Lack of evidence of 5-year supply. Well, you've got those points. Failure of policy. Section 8 of the Housing Act 1984 is a statutory requirement and requires local authorities. I should just pause and say, because I know that my learned friend has mentioned Section 8 a number of occasions, and I always intended to refer to this, so I haven't stolen his thunder in any way. Section 8 of the Housing Act is a statutory requirement that requires a local authority to assess and address the needs of people residing in and resorting to their district. It includes the duty to consider the needs of people with respect to the need for caravans. Likewise, paragraph 63 of the NPPF requires that size, type and tenure of travellers' accommodation must be assessed and their need reflected in appropriate planning policies. Footnote 27 of paragraph 6 sets out that those travellers meeting the definition set out in the NPPF, their needs should be assessed in accordance with that document. This footnote must now be interpreted on the basis of the 2024 definition. It's clear that in this case, there is no assessment based on the 24 definition. Sorry, I think you can, that's cut and paste. I'd ask you to take out those 3 lines.
Which lines am I taking?
After that document, sir.
So the sentence beginning this footnote
Yes,
to the end of the paragraph?
yes, sir.
Thank you.
We say that there has been a significant failure of policy here. The local plan policy part 1 and 2 was based on the 2015 definition. This has left the council with no allocation sufficient to meet the minimum needs assessed in the 2025 GTA based on the corrected definition set out in the PPGS 2024. The current plan policy did not properly address the needs of those caught by Section 8 of the Housing Act and paragraph 63 of the NPPF and does not cater for supply to meet those needs in terms of policy or allocation. The PDA is not a policy or an allocation or even a council document. We say that there has been inequality of approach and discrimination, and this engages the public sector equality duty. Relevant statute from national policy requires that not all housing needs to be met by bricks and mortar, when housing must be appropriate for the needs of those who have an aversion to bricks and mortar, specifically in relation to gypsies and travellers, and those who have a tradition of living in caravans, which require their needs to be met by appropriate caravan site accommodation. At present, this council has no up-to-date policy, no allocations, no way of meeting the assessed need or actual need. The PDA has no status of authority to address these failures, or authority to address these failures. Indeed, it has itself failed to address the change of definition, which requires provision to be made not just for gypsy and travellers, but for a wider group of travellers than those of either nomadic habit or cultural ethnicity. Just pause there, sir, because I think that's the failure of the way that Mr. Jarman has addressed the 28 and the ongoing need. Public sector equality duty, so I've already addressed that. Compliance with policy AHN 4 and presumption in favour, so I've addressed that. Likely location of any gypsy site will be in Stovolds area and the AGLV and or countryside. This cannot now be disputed in view of the PDA proposals for the expansion of Lydia Park. Any new site is likely to be in this part of the countryside. This significance, in fact, cannot be ignored and must be put in the balance, given significant weight to the balance. Personal need for a site, sir, and the best interests of the children. So I cite the case law of Collins and of Stevens there fully, particularly the fact that to Mr. Justice Hinkingbottom's paragraph 69 of Stevens was specifically endorsed in the Court of Appeal in Collins. And when I cite the points. One of the most important ones, sir, is that no other consideration must be given as more importance to them greater weight than the best interests of children, merely by virtue of inherent nature from the context of the individual case. Further, the best interests of children must be kept at the forefront of a decision maker's mind as he examines all material consideration, performs the exercise of planning and judgment of the basis of them. So clearly those considerations are to be applied here. And so if I could just read to you Roman numeral 6, whether the decision maker has properly performed this exercise is a question of substance, not form. So I've then listed welfare and health considerations. So I'm not, there are compelling welfare considerations here, so you know what they are. You've looked at them. Those themselves are justification just by themselves in my respectful submission in any permission being granted here. So just to suggest that the best interests of those concerned are better on the road than on this side, when you look at those compelling welfare considerations, I'm afraid is nonsense. Returning to road, having no settled base and remaining either on the road or doubling up is not a long-term option for families. It would not be proportionate to ignore their pressing need for a settled base, particularly in circumstances where the council's own policy offends against the Equalities Act and the public sector equality duty. We say this should be given significant weight. The advantages of a settled base have been set out in paragraph 13 of the PTS. So I've then come to conclusion on the balance, which I will read, it won't be very much further. It's admitted the tilted balance applies. Development is not inappropriate and planning permission should be granted. In the alternative, the inspector should find that the development does not cause any unacceptable harm to on the countryside and is asked to conclude that even with personal circumstances, without personal circumstances, the material considerations identified above clearly outweigh the harm. I've taken out by way of inappropriacy, should grant planning permission subject to appropriate conditions to deal with biodiversity and service water drainage. The fact this site can go towards meeting the shortfall in need for those who meet the current definition should carry significant weight, particularly taking into account the council's historic and continuing failure to facilitate gypsy way of life for all gypsies and meet the 2024 definition, both in policy and under their statutory obligations. This site is clearly deliverable now to meet a recognised need. There is no justification for further delay. Any of the material considerations taken above may be sufficient. Taken together, they present an overwhelming balance in favour of granting a full planning permission. It is further submitted that under the human rights balance to be struck, it cannot be in the circumstances be proportionate not to grant the application or restrict in policy terms to a temporary consent. So I've unaddressed temporary consent. In that regard, if the inspector has any concerns as to the permanent use of the site or wish to give a chance that PDA aspirations would develop into something more tangible, then a 5-year temporary consent could be a proportionate approach or would give time for the council to identify suitable available alternative sites, albeit so it won't be this council, it'll be their predecessor. Further, any alternative to addressing the service water drainage harm by condition, as an alternative to addressing the service water drainage harm by condition, the inspector could grant a 3-year consent to give time for the appellants to undertake the modelling and reinstate the drainage ditches so as to demonstrate the harm has been addressed. Alternatives, personal consent, sir, you know what that is. If you find that personal consent is pivotal, then you'll find that. So those are my submissions.
Thank you, Mr. Masters. Can I
apologise again, sir, for the many typos?
There's no need whatsoever. Just a few queries, please. I'd just like to check with you, Mr. Masters. Can we go to page 3 and 1.1.5? I'm not sure about that I've picked up the council have conceded that their plan is not up to date. That may be your understanding or interpretation. But in terms of they themselves conceding, I'm not sure that's the case in terms of what I've heard.
Well, I thought Mr. Ward went there, so particularly when he accepted that the numbers of allocations could not meet the need.
That's a separate point. You're then putting words into their mouth. that
Then I accept, sir, but
in terms
it
of,
may be
in
my
terms of
interpret.
explicitly saying our local plan is not up to date, I don't recollect hearing that.
I'm content for you to accept, I'm content to accept that, sir. It's probably my interpretation of the way that I understood Mr. Ward was accepting a position.
Okay, can we go to page 12, paragraph 215? Third line from the bottom. It says forcing the families to remain on the road. None of them are on the road. They're all on the sites.
Sorry, that should read forcing the families to return to the road.
Yeah. I'm not sure that they all came directly from the road either. I'd have to check that, but it's certainly not remain.
Yeah.
I don't need to go there now. I've got the evidence.
The point I'm trying to make, sir, is that there is no alternative accommodation.
I understand the general point. I'm just
Well,
checking points of detail to make sure that I understand
Yep.
what's being said in the closing submissions.
So there are some misnumbering. I noticed there's a couple of 2-1-3s,
Don't worry about that.
but I did my best. But I was running out of time to get here.
And the next point, I know you dealt with this, and I just missed what you said by way of correction. I'm on page 18, paragraph 3.123, and it's the numbers at Dunsford. And I know there's a typo of 18,000. What did you actually say when you updated it?
So it was an aside. I read somewhere else that the actual planning commission was at 25,000. 2,600. 2,600? Not 18,000. Okay.
So there's an extra zero, is there, Mr. Masters?
Yeah, but I've got too many zeros. So.
Okay. Perhaps easily dealt with.
I'm grateful to my learning friends.
A similar point to one I've already asked about on page 19 and 3.126. You say second sentence, the pictures were sold with hard standing and roads in place. I know that's the evidence. You then say that's accepted by the council.
Yes,
I'm just not sure I've heard that in terms.
Well, so they didn't challenge it. They had every opportunity to challenge it.
Different point whether or not they challenge it. Just because they don't challenge it doesn't necessarily mean that they explicitly accept it.
Well, so then you have unchallenged evidence about what the position is, and you've heard from no one else.
Well, maybe that's the case.
Yeah.
I'm not saying it isn't.
Okay. I mean, Mr. Lintoff, if it was likely that he didn't accept it, would have challenged it. I would have thought.
Similar point in 412, same page at the bottom.
Yes.
No suitable alternative sites conceded. Again,
Well, so
I think saying that in terms may be going
no,
beyond
so
what I've heard.
I did put to Mr. Ward this quite clearly. I asked him whether any sites were currently available at this moment to meet the need, and he accepted there weren't. That was his evidence, because I took him.
Well, there's been evidence in the case of the local plan allocations, the existing local plan.
Well, they're not available at the moment to meet the need for these families. That's what Mr. Ward accepted.
But I don't want to go into the evidence. My point is just whether it's correct to say it's conceded.
Well, that's if you think I'm wrong, so when you look at the evidence, you'll correct me.
Can we go next to page 21 and 417?
As I said, sir, what I say isn't evidence.
And in 417, you're dealing with the changed definition in the PPTS.
Yes.
And you say it requires provision to be made not just for gypsy travellers, but for a wider group of travellers than those of either nomadic habit. The definition in the PPTS starts off referring to persons of nomadic habit of life.
Yes, sir, but it goes on to extend that. And that was the point.
Well, it goes on to say, and all other persons with a cultural tradition of nomadism.
Yes, and all other persons with a cultural tradition of nomadism.
Yes.
And this is a point that was made by Mr. Woods, quoting the appeal decision of the inspector who looked at this in some detail, and we rely upon that evidence.
Yes. But the
Mr.
definition,
Wadsworth-
the definition doesn't go away from referring to a nomadic habit of life or nomadism.
extends it, sir, beyond that. That's the point I make. And it
Oh.
is an extension. That's what it does. It's quite interesting.
Well, I've got it in front of me. I
Yeah.
can see what it says. and
Yeah.
it's- I think that's it. Those are the points I wanted to check
Thank
with
you,
you.
sir.
Thanks, Mr. Masters.
So I hope I was not that much longer than an hour. If I was, I apologise.
Right, Mr. Cottle, your turn at last. Thanks, Mr. Cottle. When you're ready, Mr. Cottle, please.
Just by way of introduction, the closing submissions contain some personal details. I won't necessarily read out the names and ages of the children, and the authority have agreed to redact any personal details before it goes on the website. And there's also a warning in relation to paragraph 36 when I'm referring to a summary of mapping position that I wanted to have before you. And that's subject to the fact that you've made a direction for the parties to provide a note in response to the questions that you'd asked about the categories of risk, etc. And so I've got an exclamation mark against that paragraph when we reach it. So here we go with the appellant's closing submissions on Appeal B. The appellant's family have a pressing need for a site, and allowing the appeal would meet that need in a not unsustainable location without an unacceptable physical or visual impact, so meeting the requirements of the most important and relevant local plan policy, AHN4. The importance of the extended family as present on the adjacent Lydia Park is part of the cultural tradition. But in this case, the family on Lydia Park provides a critically important support for the appellant's wife. And that is a locational need with particular facilities at a special needs school for their son, who settled in. Dislocation of arrangements for caring for his needs makes allowing the appeal on terms of a personal planning permission the appropriate response, at least until the new authority gets a chance to decide how it will provide the required level of site provision, or at least until there's been an opportunity to implement a coherent drainage strategy. To the extent there is conflict with AHN4, limited weight is appropriate because presently there are not enough allocations to meet the 5-year need, and because as accepted by Inspector Gilbert, as accepted by the High Court, and as you are asked to accept, the owners of the sites at Waverley, that Waverley rely on, that are big enough, have not been prepared or to sell or rent 3 pitches large enough for the exclusive use of the families on Appeal Site B to the appellant. That was unchallenged. And then paragraph 3 I should take as read. There is a public interest and strong legislative and policy emphasis that our future citizens get full opportunities as they develop so they can thrive and participate fully in society as they grow up, not done on the roadside. This is not just a personal interest of the site residents against the personal interest of the owners of the neighbouring houses. That's not the dichotomy. There is a strong public interest in the educational needs of Irish travellers being met, and the councillor who last spoke also expressed this as a matter of public concern. It is a race equality issue if the decision does not advance equality of opportunity for members of a minority to whom the Secretary of State owes a positive duty to facilitate their way of life. And this is done by granting planning permission onerously conditioned that makes sure concerns properly shared by all regarding management of surface water flood risk without displacement of flood water elsewhere, which would be a community benefit and which makes sure ecology issues and landscape are comprehensively addressed. The health need is another very powerful propeller to the appellant's case, which on its own properly matches the weight you attach to the effect on the countryside as the LPA rely on. Landscape harm. The LPA's case against Appeal B, as expressed through Mr. Ward, is that substantial weight should be given to the impact of the appeal site on the countryside in terms of harm to the character and the visual impact. And substantial weight should also be given to the landscape and to the AONB and AGLV, which is double counting. There is a gradation of harm which is accepted to the extent that the relevant part of the former field will be occupied by the appeal site, even if the landscape and visual harm is significant. Though the appellant's case is that it isn't, it is still submitted that the proposal is designed to mitigate harm and the appeal should still be allowed. Whether or not a site is in a valued landscape should be approached on a site-specific basis because the importance to attach to any given feature will vary according to the location, which is here marked by the presence of Lydia Park. Arguing that a proposal must enhance and conserve because similar protection to the national landscape is to be applied as per RE3 is a relic from the past and should, as per paragraph 232 of the NPPF, regarded as such. It is trite law rather than planning judgment to observe that limited weight is to be given to policies that are out of date. The judgment is whether they are out of date and what consequences should flow from that. You can see the different tests and the different responses that, for example, AHN4 and RE3 supply. The context and location of the site includes the permissions granted notwithstanding the location in or adjacent to the national landscape for a fracking site, a solar farm, a brewery and 2,600 homes on the aerodrome nearby. By virtue of the NPPF, what matters is the degree to which you find the site adversely affects the setting of the national landscape. If allowing the appeal does not materially affect the national landscape, all well and good. But if against the appellant's case, you nevertheless found the appeal site to be in the setting of the national landscape, your obligations are properly discharged by applying the NPPF, which encapsulates the matters you must address, making sure with the purposes of designation in mind that as much as possible is done to curb the risk of any future harm to the setting. Doing as much as you can to conserve and enhance the national landscape, given the starting point that Appeal B is at the lowest end of harm to the setting of the national landscape. If that, from the lowest point view, figure 8, under paragraph 511 of Mr. Dudley's proof, you are invited to add to the landscaping condition a condition addressing concern that given ground conditions, planting would not take effect, will not take up. It's just a matter of how deep the ground is prepared before the planting takes place, which could be monitored in a retention schedule. For example, any trees, shrub, plants or hedges planted in accordance with the approved scheme, which are removed, die or become diseased or become seriously damaged within 5 years of completion of the approved soft landscaping scheme shall be replaced with the next planting season by trees, shrubs or hedges of a similar size and species to that originally approved. Even if the appeal site would cause the moderate harm to the national landscape, the appeal can still be properly allowed because, recall the Protect Dunsfold decision ID 20, it's not axiomatic that moderate harm must attract great weight. It simply does not follow that because Lydia Park might be regarded or is in the setting of the national landscape because it is in the foreground of views from figure 8, the top view point of the site visit, that great weight has to be applied against allowing Appeal B because that is completely the wrong approach. Appeal site B cannot be seen from there. No harm is caused to that receptor, and to the extent views may be different when there are less leaves during winter time, then it is submitted appeal site B would be undiscernible given the distance from Lydia Park and the obvious caravans on higher ground south of Crocus Lane that the eye is drawn to. Mr. Dudley considered because it was an AGLV, it must by definition be valued, but did not independently assess it according to the TGNOT 21. The site included a wooded corridor, itself a priority habitat. In that sense, when the trees were there, it may have qualified as being valued, but granting planning permission does not cause the loss of any of it. This definitional assessment undermines his appraisal. Mr. Ward's evidence at CD 86 is relatively long, but at page 44, he does summarise Mr. Dudley's evidence, and here are extracts. And then that can be taken out as read, the landscape effects, the visual effects. And at the bottom of that, uses a public footpath Hascombe 279, it's said that there's a major moderate, and it's uses a public footpath Bramley 277 major adverse. You are entitled to disagree with all of the above, and I add there, particularly the summary of visual effects. You are invited to do so as it does not accord with what you saw with your own eyes today. The closest viewpoint from within the national landscape is figure 8 under 5.11 of Mr. Dudley's evidence. This is the longer view by the barn above the Dunsville corner. This is at the bottom end of the scale of visual harm. That is because, firstly, on the slightly higher ground to the side of the path to the left of this viewpoint as you ascend is off the public footpath, as is the slightly higher ground to the right, and neither are public viewpoints. The only reason for going there is to better make out what you are seeing, because it's not clear what you're looking at from the path itself. And a recreational walker would not notice Appeal Site B in distinction from the Lydia Park caravans that the eye is drawn to once landscaped. From the middle of the path, you really have to work at discerning Appeal Site B, and the two mobile homes presently in view at the southern end of the appeal site would not be there. Instead, it would be the landscaping and hedging and the home on the southernmost pitch perpendicular to Crocus Lane that would not extend down as far as the brown mobile home you saw closest to Crocus Lane that would not be there. Your attention is now invited to figure 7, the highest point reached on the site visit shown in Mr. Dudley's proof. Under paragraph 7, Appeal Site B is too far to be distinguishable. And I add there, even in winter. We stopped at a gate near Thatched House Farm, which enters ground used for accessing the land behind the appeal site, which Mr. Simon Doherty wanted you to see. The appeal sites could not be seen. Between there and before we reached the right angle of Dunsfold Road, opposite where we walked up, all that could be seen was the top corner of land of appeal sites represented by Mr. Rowe and Mr. Masters, but Appeal Site B was not visible, nor it could be made out from standing on the raised ground on the near side edge of the right angle corner in the road. Knowing as you do now that Appeal Site presently has brown mobile homes on it, even from the outside curve of the right angle corner of the road, Appeal Site B is not visible. Once landscaping has had an opportunity to take root, the point made about much of the vegetation being deciduous would be overcome by the further hedge growth, which would be in keeping with the rest of what you saw. There was no incongruity experienced on the site visit from the promontory that would be formed by Appeal Site B if the appeal is allowed, which Mr. Dudley spoke of in his oral evidence, best apparent from aerial photographs only. It is submitted that Mr. Dudley has not applied AHN 4 as was required. He has not had regard to how the locality has accommodated changes, including the aerodrome development, and he's ignored the local character, including Lydia Park and the caravans behind it going up Stovolds Hill, which have been present for over 30 years. It is also contradictory that so many permissions have been granted at Lydia Park since 2017, and I was unaware until I saw the notes, sir, that there was one in March 2026 as well, without attaching any landscaping conditions, yet they are in the AGLV, and since the summer of 2021, more permissions as recently as March 2026 have been granted without concern for the impact on the setting of the national landscape, and now the LPA propose to further intensify Lydia Park without any issue being raised over landscape in the pitch delivery assessment, or whether they might be visible from the footpath you visited on your site visit. The LPA can't be allowed to have it both ways. It is a single legal entity and cannot advance contradictory positions, which it has done over landscape domination and flooding. The permissions at Lydia Park also lack conditions controlling nighttime light pollution, contrary to the Bramley Neighbourhood Development Plan. The November 2025 permission did include control of lights at night, and you're invited to attach a similar one here. Domination. The dictionary definition of the word dominate refers to the word being used in different contexts. In a geographical sense, a colossal rock may dominate a town or settlement. There should be a check to see what would be said about the addition of 3 houses built by a modern developer in this location, or there could be an unconscious bias which is to be rejected because of fear of the unknown from a different culture. The policy must not be construed to operate or sanction discrimination. It is submitted that the locality includes the aerodrome, which is equidistant, if not closer, to some of the scattered dwellings off Stovolds Hill, and there is no knock-on pressure on services, nor infrastructure concerns if Appeal B is allowed. Since Inspector Gilbert accepted the LPA's argument on domination 4 years ago, the LPA has gone on to grant more permissions and still propose to further intensify rather than to reduce the scale of Lydia Park. So it frankly does not lie in their mouth to argue domination when the LPA is so obviously not concerned about numbers, and they are right about that. It is, as Mr. Woods said about the spatial impact of the appeal site on the countryside, hence the justification not shared by the parish councils about infilling. The arguments supporting the LPA's case for not extending Lydia Park north of Crocus Lane are outweighed in this case, at least for the purposes of a temporary, if not a permanent planning permission, due to compelling health need, as well as the substantial weight to children's best interests. You are invited to agree that the weight that children's best interests attract, assuming you agree it is better to make the permission conditional on flooding matters being subject of an engineering solution, which if not found would mean the permission would fail, is no less than the equivalent amount of weight you attach to any perceived need not to enlarge the size of Lydia Park whilst new provision is adopted. Alternatively, the appellant's case is that any such harm as you identify attracts only limited weight because the antisocial behavioural allegations are not added to by the appellant and in any event are a matter for the police. If you take the view that a cluster of dwellings may constitute the settled community, you are nevertheless invited to accept Mr. Wood's evidence that it would be wrong to ignore the fact that the settled community, while presently in the minority, will soon be in the majority once the housing on the aerodrome exists. The present domination issue is therefore time limited and should not be decisive when there are no infrastructure implications that would arise by allowing the appeal. Next subject, intentional unauthorised development. The most damage to the environment occasioned by the loss of the trees predates the appellant's acquisition of the site, as did the hard standings shown on the photograph which interfered with the ditch. And the appellant did not move on until September 2022, at about the same time as the planning application. The appellant did not carry out these works. Consequently, it's clear they do not amount to intentional unauthorised development by the appellant. The appellant must be shown to have intended the development to be unauthorised or actively sought to harmfully flout the rules. There's not the evidence of that, and once the LPA applied for him to be removed from the land, the court refused. Mr. Doherty did not go onto his land until he had no choice. That is mitigation. Flooding. The appeal site lies within flood zone 1. The appeal site forms part of the wider land west of Stovolds Hill, north of Lydia Park, arranged broadly north to south with shared access from Stovolds Hill and a local drainage corridor along the southern frontage access route. The behaviour of surface water in this location is governed by the local topography, and the severely impaired drainage ditch and the broader flow path, as described by Mr. Herman, runs across the land heading towards and under Stovolds Hill Road. The LPA's case alleges an inability to provide safe conditions, hence best interest of the children not to live there, and alleges an inability to avoid increasing flood risk elsewhere. Both parts of the case can be met by condition or alternatively by a temporary permission if deemed more appropriate that caters for a sufficient time for a fresh application in respect of drainage matters and for necessary works to be carried out. The inspector asked a base date for UK flood maps 4 and E8 mapping, both the date introduced and the date of the data information, categories of risk and what these relate to in terms of flooding event and what depth of water is covered by the two mapping systems. And there has been a note provided by Mr. Quigg from Flume, but we're going to reserve that evidence until we put in a note with the authorities. So I'd just like you to note that it may be the case that we agree to disagree over some of the inferences, but we'll hopefully try and agree just the non-contentious answers to the questions that the inspector has asked.
It's not for me to speak in my own defence. closing, but I just note that the summary of mapping position he's provided there doesn't seem to address the factual matters that you asked for and seems to present some commentary on things as well.
Just the first question. So I put a health warning around that and say it's subject to the note that you're going to be provided with. You're reminded that Mr. Smythe eventually accepted that in order to assess the likely depth of flooding, that modelling would be required. It is submitted that rather than basing assessment on how matters were in November 2024, and he said a 1 in 6.7 year event in terms of rainfall, with an unmanaged state of affairs, the likely depths should be informed by site-specific levels once the watercourse is reinstated. The LLFA email exchange is to be found at CD 12B.2. In the Flume report for Appeal A, reference was made to a drainage channel system, C14, page 14, 16 internal numbering, and page 15 of 17 if you're using electronic numbering. And the FA spoke of ensuring surface water off the appeal site running to the watercourse. See also the evidence from Mr. Woods when he spoke of a system of drains on site to convey the surface water down to the watercourse. It is not rocket science. What Flume suggested for Appeal A can be done on Appeal Site B as well. The under report did not understand the problem the hard standing caused to the watercourse. The problem is the present unmanaged condition with the severely restricted flow path due to the pipe under the hard standing. Yet Mr. Smythe draws his conclusions from the unmanaged state of affairs. That is incorrect. Instead, you are asked to assess matters on the basis of how it would be if service drainage was properly managed, to which there will be, as Mr. Woods explained, an engineering solution that will benefit all those using Crocus Lane and which will be of significant benefit. 4 pages earlier in the Flume report, electronic page 11 of 17, there is a blue box comparing the Environment Agency mapping with UK Flood 4 model levels, which you are invited to accept are more accurate since the Environment Agency mapping is not reliable for property-specific assessment. Appeal decision letters. Mention was made of the Calfoud Lane decision dated 13th of May 2014, and at para 11, the suggestion of a condition to address flood risk was given short shrift, but here a sequential test has been undertaken, and it is shown that there are no reasonable alternative sites, and the unsuccessful arguments used there is not relied on here, that all we are obliged to do is look at allocated sites, hence the discussion of Culmer Lane, the site with the access via the public right-of-way affecting ancient woodland and in Greenbelt. Mention was also made of the Gullgate Lancaster decision of 27th of February 24, in which at paragraph 33, it was said that the appellant had failed to compare the extent of flood risk when conducting the sequential test, but that part of the local planning authority's case does not work in relation to Appeal B, because in any such comparison, the fact no land used to station caravans on would be affected by flood risk means the appeal site is preferable. Your attention is drawn to the appeal decisions, one of which is one of your own decisions, attached to the WS planning response or rebuttal to the GTA and the PDA regarding the council's unrealistic reliance or misplaced confidence in the PDA yielding the pitches they rely on. ORS were mistaken to recommend to the council that they be commissioned to do one. Safety and exception test. The council relied on photographs taken during wet conditions showing ponding and shallow water flowing across Crocus Lane, but it is submitted that the present unmanaged condition does not establish that the appeal site B cannot be made safe or that it must increase flood risk elsewhere. It is accepted that caravans are vulnerable as per Annex 3 to the MPPF, but risk of surface water flooding is not categorised into flood zones 1 to 3. National flood policy in the National Planning Framework and Planning Policy Guidance provides that development be directed away from the areas of highest flood risk and that permission should be refused if there are reasonable alternative sites appropriate for the proposed development in areas with a lower risk of flooding. The MPPF provides that if there are no such sites, the exception test may have to be applied. Under that test, development can only be permitted if the development would provide wider sustainabilities to the community which would outweigh flood risk. The development would be safe for its lifetime, taking account of the vulnerability of the users without increasing flood risk elsewhere, and where possible, will reduce flood risk overall. The purpose of the conditions in respect to flood risk are precisely to stop flood risk elsewhere, as envisaged by the lead local flood authority response. Making the permission conditioned in this way also permits the possibility of reducing flood risk overall. My cross-examination of Mr. Ward ran through the wider sustainabilities, which he accepted, and the risk of surface water flooding, once conditioned, would be outweighed. All parts of the site in residential use would be safe for the lifetime of the permission, as they are on higher ground. The risk of surface water flooding to those living there is not such a risk as to mean planning permission should be refused, since they can stay dry. A condition could prohibit residential use in the car park area, as it would also be achieved by a functional limitation that granted permission in accordance with the submitted plans. It submitted that the sequential test has been met by reason of Mr. Wood's evidence. And so I would like you to note that DS 15 Burnt Hill, there was reference to that site being in flood zone 3, and DS 17 was a site with one pitch with a family on it, and DS 19 was also one pitch with a family site, and the reference to the plan is CD 6A.7, not 6. It submitted A.7. I think we were given a reference of CDA 6A.6, which is wrong. It submitted that the sequential test has been met by reason of Mr. Wood's evidence, and because applying what is meant by a reasonably alternative site, it is right to accept that the appellant has a locational need to live at Lydia Park due to the family support there obtained on behalf of their son. The borough-wide area of search conducted by Mr. Woods was not unreasonable, and his evidence that the smaller parcels of land were more difficult to acquire than larger ones, hence he looked for larger 0.3 hectare sites for the 4 pitches for both Thomas and Simon. You could also justify that by reason of Thomas needing extra space due to his equestrian equipment, or for additional space for children's play area. It's not unreasonable size to have looked for. It is submitted that the underlying policy of successive different governments has always had the core requirement of safety and not displacing water elsewhere. You therefore have to deal with the issue of safety, and that assessment should be done with the watercourse reinstated, whether by condition or temporary permission, should you think that is preferable. Pending compliance with the drainage condition, the situation is safer than not having anywhere else to live. You are asked to disagree with Mr. Ward about this assessment, of which outcome would be in the best interest of the child, because it is in the best interest of the children that there should first be an opportunity for hydraulic modelling and implementation of a coherent drainage strategy. It would be disproportionate and incompatible with the respect required by the HRA for the Article 8 rights of Mr. Doherty's families to dismiss the appeals before the scope for effective surface water drainage management has been thoroughly assessed, and if possible, then implemented as conditions can require. Next subject, ecology. The 5-metre buffer zone from the watercourse in policy NE2 can be obtained on the appeal side. This was not a reason for refusal, nor relied on in the LPA's statement of case. And this was not raised in the condition session, but you can condition appeal site B to stop built development in the area south of the last pitch reserved for parking of cars, as was discussed in the evidence. There is no rule that due to the lack of satisfactory ecological surveys, and it is accepted that those that have been done did recommend further studies not carried out, means planning permission cannot be granted. The Surrey Wildlife Trust consultation response did not object. See CD 12B.3. On the contrary, the reason for refusal in this case can be addressed by the sources of conditions imposed in the Thatch House Farm Planning Permission. It is contradictory for that not to be true. The decision was not a mistake in that case. The loss of habitat that greater crested newts might well have used, or that greater crested newts will continue to migrate towards, is a material consideration in the appeal, but the refugia in the mitigation plan in ID 7, implemented pursuant to the Lawn Hill decision letter of Inspector MacDonald at ID 18. The pre-existing hard standing must still have been traversed by the greater crested newts in that case, does not mean you should not look at ID point 7 in order to understand the enhancements and bonuses that can be achieved by effective conditioning. The point of ID 18 is to show you the methodology, even though no proper surveys had been done beforehand. You have sufficient information based on the thatched house farm permission and the example of effective mitigation for this reason for refusal to be overcome and attract only limited weight because effective conditions allowing dedicated planting to encourage the wood white butterfly, if ever there, bat boxes and refugia. Material considerations in favour of allowing the appeal. You are referred to Mr. Ward's appraisal, which is limited to medical need, best interest and personal circumstances, which he appears to regard as not severely affected because of the alleged availability of sites on Lydia Park to go to. But that is not the case. Mr. Ward is mistaken when he attributes only limited weight to the benefit of additional sites. He's also wrong to say only limited weight should be given to the benefit of providing Simon's immediate family, each with a settled base. He also wrongly telescopes down personal circumstances, medical and education needs of the family on Site B into one matter, when they are three separate matters, each attracting substantial weight. He then stops short of a full appraisal of the adult children and fails to assess the following matters, which you are invited to give significant or substantial weight to. Unmet general need. Sub-regional need is relevant. There are 128 pitches needed, or whatever element of non-travellers that may turn out to be within the definition on top of that. Plus, I would add the numbers from Legends Acre and the other two sites that Mr. Wood spoke of. It is not robust not to have asked Surrey County Council if they had inquiries for a pitch at the council site from those in bricks and mortar, and it is not robust to have a zero figure for those in housing waiting for a pitch of the Willows, when wrongly the allocation system to disqualified people, consistent with general allocation policies for conventional housing, which, as you might imagine, prioritise the homeless as against those already housed, from going on the waiting list. The 162 authorised caravans shows that resorting to the area for the purposes of Section 8, that's from the caravan count, whose accommodation need, it is the council's duty to assess. No 5-year supply. There was a problem in November 2024 when the inquiry began, as the council were relying on data collected in 2017, and need has evolved since then, not least by virtue of the unassessed future new family formations arising from permissions granted since 2018. At that stage, the council could not demonstrate a 5-year supply, and that continues to be the case. There is a need for 50, and there is no certainty that once consulted upon, the council will adopt the PDA strategy of intensifying Lydia Park. The very fact that the LPA advanced what is said in the PDA means it is not relying on flooding along Crocus Lane or on increase in numbers of caravans as a reason to count against those Lydia Park sites identified for intensification. They are right not to regard those as reasons for disregarding those sites, and they are not right for dismissing Appeal B either. Otherwise, the council is advancing contradictory arguments, which it is submitted that a sole legal entity should not be permitted to do. It is to be all in or all out, and it is all in, the truth being that flooding and numbers are not reasons for dismissing this appeal. 50 pitches are required in the next 5 years, or at least 50 pitches are required in the next 5 years, and there's no policy in place geared to providing them. The PDA has not been the subject of any committee resolution. It does not represent council policy. It's fairly remarkable that the councillor who presented the case for the parish councils, who oppose more caravans at Lydia Park, was unaware that this was being argued by the local planning authority. That is not just an embarrassment, it is wrong. No one from the council has actually appeared or given evidence to answer questions about the views of elected members and the political mandate that appears lacking. There is an apparent lack of authority to say what the PDA says. It is also remarkable that the council rely on pitches occupied by non-travellers, and looking at CW 16B, you are invited to note the frequency. It is said that a PCN was served 2 years ago in May 2024 with no subsequent enforcement against those pitches since then. CW 16 refers to the BCNs, but there's uncertainty over how long enforcement will take, not just given the gap since the PCA, which indicates a lack of resources unless something is wrong with the evidence base. But enforcement may also be lengthy because there may very well be a contest over the alleged breach. It cannot be ruled out. This undermines what is said about it being realistic that pitches will be available. There is no robust evidence that steps will be taken by this authority to produce results before it disappears, and the new authority may decide to drop the idea, perhaps even if they are non-travellers, because the hard-pressed housing authority finds it a useful resource. As the parish council seem to agree, some of the pitches said to be occupied by non-travellers are not shown in the photographs to have been laid out according to the permissions, and may argue the conditions don't apply as from day one and the permissions were never implemented. The questions attached to the GTA do not ask the relevant questions. How long have you lived in a caravan? And if I could just pause there, sir. The current definition in Annex 1 reflects what was in Section 226 of the Housing Act 2004, and it wasn't dependent on previous travelling. So you could have been brought up on a council site and never travelled in your life, perhaps worked in Clark's, the local shoe shop, but you would have a cultural tradition of living in caravans, and the new Annex definition doesn't require previous travelling. So the questions that we see in the GTA haven't been revised because the 2025 asking about why you ceased travelling doesn't ask the relevant question. And the relevant question I'm putting in here is how long have you lived in a caravan, and do you identify with living in a caravan? Those are the questions to ask in relation to the revised definition. Instead, the questions have not been revised since the new definition and are still based on ascertaining if there is a nomadic habit of life. No weight should be attached to the BDA other than an indication of what the subsequent unity authority may choose to adopt, modify, and adopt, or choose not to adopt. To be invited to somehow endorse putative sites for allocation bypasses statutory procedures enacted to ensure that community engagement is involved in the formulation of planning policy. Public consultation matters. It has not taken place. The PDA also represents poor forward planning by too small pitch sizes, unless only for existing families to expand it into, subject to other constraints. You are asked to adopt in full what is said in the WS planning rebuttal to the 2024 data first collected in the spring of 2024 before being put in abeyance, GTA and the PDA. This includes questions over the boundaries of pitches and the small sizes of pitches in Lydia Park that are not advanced as for existing family members. The exercise is not a sufficient means of defeating planning permission for Appeal Site B. Mr. Simon Doherty told you whilst under cross-examination that he did ask and could not find another site for his family at Lydia Park, and that is the end of the matter. And I should say that the evidence in the High Court proceedings, and I gave you the paragraph from the judgment where it was being put that those sites which have the information about rental pitches were available for my client to move to, and the High Court judge made a finding that they weren't. And it's based on what she heard from the defendants. And you're being told by Mr. Simon Doherty that he's gone out and he's asked and he tried and he's failed to find somewhere his family could move to. Pitches claimed to be available outside of Lydia Park are relied on for family members of existing site residents. Hence the justification for compliance with DM 37, despite smaller pitches, that was not referred to in Mr. Jarman's evidence nor in the GTA. Pitches on Lydia Park are privately owned, and the appellant has been there long enough to be able to find out if he could get somewhere and avoid the expense, or rather all this expense, of this appeal. And he told you he did ask if he could acquire land elsewhere on Lydia Park for his family's 3 pitches and found out he could not. That is what he told you before his evidence under cross-examination drew to a close. Lack of alternative sites. The lack of alternative sites is fundamental to the balancing exercise, and there are profound disability implications weighing in favour of allowing the appeals. There's a public interest in the objectives contained in Section 149 of the Equality Act. Here, most importantly, seeing the need to reduce, if not eliminate, discrimination and in promoting equality of opportunity. Interference with human rights, and these are the factors I'm counting that Mr. Ward didn't count. This is part of deciding whether or not to allow the appeal, not merely a matter that follows the event, i.e. the outcome of the decision on the planning merits. They are a material consideration indicating otherwise for the purposes of Section 38(6), so they ought to be weighed and regarded as integral to arriving at the decision. For the correct approach to interference with human rights, see the Pucklesert's decision at ID 7.2 at paragraph 49, which expounds an approach that you are invited to share. And this attracts substantial weight because of the lack of suitable alternative sites to go to. The period of a temporary seems to have been largely agreed. It's approximately 18 months if you do not consider the permission can be made conditional on implementation of a coherent drainage strategy. Because if you think, we should say 18 months or 3 years, because if you think that then the permission should either be permanent or 5 years to allow effective adopted policy allocating new sites. Disability and medical need. The son has the protected character of disability. This means that you must sharply focus on what the effects of dismissing the appeal would mean for him. There is also the health need that you're aware of as a result of the appellant and his wife's respective medical conditions. Race equality. See the introduction above and the opening statement in ID 5, because rendering those who, for want of a site, can end up on roadside encampments has race equality implications, and so did the time it took, or the best part of a decade, between assessments which there was a statutory duty to do. The fact that the GTA was put in abeyance was unjustified and caused further disadvantage. Children's best interests. See the introduction regarding the 5 children. ID 7 and the decision of Clive Hughes in the Puckle appeal again, cited above, and which Mr. Woods was taken to, and your task is to identify the outcome that would be in the best interests, and it would plainly be to stay put. There should be no question about that. See above. The tilted balance, is it disapplied? It is odd that there's not already a decision on point. The LP argue that because the impact of a development in the setting of a national landscape is dealt with amongst the paragraphs in the MPPF that address national landscapes, that must mean this case falls within footnote 7. The appellant invites you to look at the structuring of the footnote. Punctuation is key. It says, open inverted commas, ... land designated as ... national landscape ... close inverted commas, then has a semicolon and moves on to the next. So footnote 7 specifically refers to land designated as national landscape. Mr. Woods added that footnote 7 had the opportunity to add national landscape or land in the setting of a national landscape, but it was decided not to do that. And I also would like to make an aside here that habitats obviously have a technical definition in the glossary, but the planning authority weren't relying on habitats as a strong reason for disapplying. They were relying on flooding. Because its policies are affecting areas relating to areas of flooding as a reason for disapplying. Not habitats. But the point about flooding is the degree to which you're satisfied that an engineering solution will be available, given it's got to be the case that all of Lydia Park residents would benefit from that solution being found. But on the alternative submission, as I asked Mr. Woods, if you find that the tilted balance is disapplied, then we submit that the weight of material considerations that are relied on in support of the appeal are still sufficient to outweigh the harms. The difference between the appeals. The appeals must be considered individually, and you will readily accept that it's your task to determine each proposal individually on its merits. All the evidence shows visual intrusion increases heading east, with appeal site A having the least, whereas with surface water, the concern seems to go in the other way. But there's a difference of severity of the medical need between the appeals. And that could be the difference between a temporary and a permanent. I just pause there to add further submission, which is that there's also a difference of approach from the authority in choosing to serve enforcement notices on some and not on others, from which we may infer that there was a difference of treatment between the sites by the authority based on waiting to hear what you decide. And that's a reflection of the strong medical need. It is submitted that the evidence in Appeal B warrants a permanent planning permission, with the cumulative effect argument, as advanced by Mr. Ward, being rejected as wrong. In the Holland case, ID 19, the inspector concluded that the adverse impact on highway safety from the cumulative impact of 3 or more plots would be significant. But here, it's open to you to express your conclusion in such a way as to make clear what, if any, or no further development would be acceptable in terms of visual impact, and rely on your own assessment from the site visit this morning. Alternatively, you might think drawing a line across the back of Mark and Simon's site across the field would avoid the incongruous nature of any promontory. But the better view, it is submitted, is that once Appeal B landscaping has developed, any views from the national landscape would be sufficiently outweighed by the weight in favour of the matters relied on above for allowing the appeal. The individual merits of their youngest child's predicament justifies an adjustment that is a reasonable adjustment in the circumstances, because dismissing the appeal before a site large enough can be acquired would be too high a price to pay and would be disproportionate. Conclusion. The appellant's opening statement, IDO, headed Note on Material Considerations, is still relied on, save that now we have a fresh GTAA and the case for a temporary is not so confined as it was. For the reasons set out above, and ID 0, you are respectfully invited to allow Appeal B at least until the new authority has had the time to decide what it's going to do about the assessed need for over, should be 128 or pitches. A Herculean task given the constraints in the borough.
Thank you, Mr. Cottle. I think there's just a few things I just would like to check. Page 5, paragraph 1.3. Midway down the paragraph, you refer to the top viewpoint of the site visit, and I think it was agreed that was figure 7.
Funny thing is, I came back from, I'm happy, as long as you know what I'm referring to.
But you mean the
view.
highest point we went to?
Yeah.
Yeah.
Because I went into Mr. Dudley's proof and oddly found it confusing because figure 7.
I'm just
I
going
agree.
from what he said on site, so I haven't checked it with his proof since.
Forget that I referred to figure 8, just have regard it's the top viewpoint.
Yeah. Okay, thanks. I'm then going to page 13, and I just want to check. It's paragraph 37. You've said a 1 in 6.7 year. I thought it was 1 in, is it 1 in 1.67?
Yeah, it was, yeah.
Sorry. More frequent. Yes.
I don't think 1 in 6.7 is right.
Well, that's my incorrect note then.
I think it's 1 in 1.67, but I'll check anyway. Page 16, paragraph 47, there's bit I don't understand. And it's the penultimate line on page 16. Four pictures for Thomas and Simon. Are you adding A and B together there?
That's how it was approached, yes.
Right, okay. So that's A plus B.
No, I'm saying that the size of site that Mr. Woods looked for was on the basis of his 2 clients.
Even, right, even though you're making the point the appeal should be dealt with
Well,
separately.
that's what explains what he was doing.
Right, okay.
And also that it's not an unreasonable area of search to have taken the borough.
Can we go to page 18 and paragraph 53? And it's the sentence that begins the third line, the loss of habitat. And if you read it slowly, I'm just wondering if there's some missing text at the end after ID 18.
Thank you. Yes, it would address that. Well, no, ID7 implemented pursuant to law and health decision that would address that, yes. So basically you're providing with a resort when they get there, they've got
Yes, I just felt that the way it read it.
somewhere they can resort to.
And I think the last, yeah, it is the last one on page 24, paragraph 75. And I don't think, you say the period of a temporary permission, and you refer to a period of 18 months in relation to drainage. I don't think that has been agreed, because I think Mr. Wood said 3 years.
Well, I think that's right. I corrected it as I was reading 18 months or 3 years. I stand to be corrected.
Mr.
18
Wood-
months was discussed, then.
Yes, but I
I
think,
said 3 years, yeah.
but 3 years, was it Mr. Masters who said 3 years in his closings? So are we having, is the suggestion then, Mr. Cottlitz, different temporary periods for different sites in terms of
Well,
drainage?
it's open to you, and I'm wrong about saying it was agreed on 18 months, obviously.
Right, but 18 months is your position for?
No, 18 months was discussed, as Mr.
Yes.
Wood said.
That's quite right. Yeah, I'm just trying to find out where we particularly reached. Okay. I take it from something you said, I think it may have been while you were delivering your closings, that you've now seen the note from Mr. Jarman. I wanted to make sure that you had the opportunity to see that.
Well, we have covered all the issues under paragraph 3. There are 2, 4, 6, 8, 10, 8 bullet points or so from DS 15 through to DS 20.
This is in the note.
That's right.
Yes, something I haven't seen.
Oh, right. It, for example, says DS 17 Monkton Farm 5 allocated pitch added as a supply. And you've already got our evidence in the rebuttal that's existing 1 pitch site again for the family. And DS 18 Kilside Place clients of WS planning, and it's for his family. And these are all things that we've already said in our rebuttal. So when he's putting these things forward, it's irrespective of the fact that we've rebutted it.
Okay,
So it's all disputed.
sorry, Mr. Master, I can't hear you.
So I think you were hoping to get a statement of fact that was agreed. It's not agreed. We don't agree with a note at all.
But from what Mr. Cottle says, it isn't new in any event. He's aware of the points.
Yeah.
Right, outstanding information. I already mentioned the TPO, which the council have in hand. Schedule of occupants, you're going to sort that out. That's in hand with you, Mr. Masters. Yeah. But I think for anything that's not ready now, I'll just give one date, and if the straightforward things by the end of this week, please. And your schedule likewise, Mr. Cottle.
I believe it was sent yesterday, the schedule.
All right, that's okay.
Yes, but
That's been sent. I think you may have mentioned it actually.
you're going to give a direction on drainage for the parties.
Well,
to have.
that's the next point. Yes.
Perhaps it's Thursday today, perhaps early next week.
It's Wednesday, according to me.
That's definitely a point of fact.
We can agree on that. I'm happy to, if it would facilitate getting an agreed note, I'm happy to allow till a week on Friday.
All I can say, Inspector, is that we sent it 3 times on Friday. We sent it again, and we just didn't have anything back.
I understand that.
So we are a bit frustrated about that, and the note is very clear. You've seen it. It's a series of facts. So I don't see why it can't just be responded to and said that these facts either are or aren't agreed. So there's nothing else for us to do. It depends what you want to give as a matter of time for people to come back. But I will say, in terms of what's put in Malone and Friends closing, that's just not helpful because it's not addressing what you asked to be addressed. The note does do that.
Well, yeah, my understanding, Mr. Lindsay, was that section there was subject to what was in the note, and it may be able to be disregarded, that the note would supersede it, which is my hope.
But I do reserve the fact that parties may agree to disagree.
Well, you mentioned that earlier. I mean, my hope would be that if we're dealing with matters of fact, we don't get to that position. But I'll give till a week on Friday for that to come in whatever form it does.
And perhaps what could be helpful is if the note could be annotated in respect of each fact, and if it's not agreed, it could be said that this isn't agreed, the fact is, and then this fact, and then it could be clear to you what the facts are that's being said are different.
As long as it's clear,
I think if it's clear, sir, I think if you allow Mr. Lintoff to dictate terms of how we do it, it'll probably just add to the problems. I'm sure that we've said.
So it's a matter for we're talking about an agreed document, which is a matter for the parties.
Yeah, exactly, sir.
Okay. Is that it? Is there anything else outstanding that the parties have a note of that I haven't mentioned? Good. Can I do a final check on, because I should do at the end, on cost applications? Indication is none. I presume that remains the case.
Just thinking that whoever's listening to the thing from afar is probably saying to themselves, those barristers, we don't even know the day of a week.
I'm sorry.
That's a different point. One of the, but I'd say for the record, it's just one of the barristers that didn't know the day of the week. But in answer to your question, no, Inspector, no change.
Good. Thank you very much for that. Well, time now for me to close the inquiry. Thank you all for your contributions over an unusually extended period, and thank you for putting up with that and coming back both last year and this year to put the evidence before me. Thank you. The inquiry is now closed.
So can I just thank the staff and generally for Waverley, who have been very helpful in so many other ways.
Thank you.
And that includes my opponent, Mr. Ward.
Thank you very much, Inspector.
Thank you. And just one final thing now that the inquiry is closed. As you know, I've got one large box on either side of me. I need to arrange for a courier to take these back to where I'm going. So I just need to have a conversation with Mr. Bennett. That's all I'll be talking to Mr. Bennett about. But yes, but I just need to be upfront about it. Okay, thank you very much.
No dead bodies, I hope so.